We're voting on position number 5 and 10.
From the trial calendar? Okay. And Deputy Gordon said Malik Henderson is here today. He's not on.
If I recall,
No, Caldwell. You had Caldwell brought over for Ms. Simpson, which was great. That was helpful for her. I don't know where she went, but she's talking to Caldwell. So Caldwell will be done. Excellent. Malik Henderson is, well, we'll talk about it. I just didn't see him on a calendar anywhere. All right. Sorry for the delay and good morning again. We have a trial calendar to call today. The trial calendar, I don't have that. Thanks. The trial calendar actually starts not next Monday, but the Monday after, 1 week trial calendar. So the cases here, if we don't resolve them today, I'll send an email out to the lawyers as the short list of the people who need to be here on Monday, the 23rd for trial. With that, position 1 is already resolved. Position 2 is Douglas Hairston. I see Mr. Banks online. Good morning, sir.
Good morning, Judge.
Add you to the screen there. We'll get the podium back on. I think Ms. Willingham is here. Good morning, Ms. Willingham.
Good morning.
Ms. Willingham, is the state ready to go on Hairston?
State's ready.
Okay, and Mr. Banks?
We'll be ready, Judge.
Okay, I have us, the three of us, down for a pretrial meeting on Friday, the 20th at 9. You're welcome to Zoom into that. You don't have to be here in court, but it's just a final touching base to make sure everything's ready to go. This is a case that Mr. Banks, you've very graciously taken over and have been juggling a lot of pieces with it. I just want to ensure that if there are any hiccups, we've got Friday to work through them. We can talk about any pretrial issues. I won't make any rulings. Your client won't be here. It's informal. It's just process related so that come Monday, the 23rd, if this is the case that goes out, we are focused on, hey, Mr. Colwell.
How you doing, Judge?
Better now that I see you. That we're focused on jury selection and handling a few motions in limine. So Mr. Hairston is here right now. He will be here on Monday, the 23rd. I don't plan on bringing him over on the 20th because I figured we'd just talk shop in an informal way. But I can change that, Mr. Banks, if you think, one, you want to be here in person and you want Mr. Hairston here.
I don't need him here, Judge, and I can be in person or virtually, whatever the court's pleasure.
All right, Zoom is easier. I got a bunch of other stuff that day anyway, and Ms. Willingham's nodding her head. Please don't make me come to court. So
Zoom is perfectly fine for me.
we'll do that. So we'll just connect at 9, and it could be a 2-minute conversation that all systems are go. We just had a few bumps before, and I understand it takes a lot to get everyone here to court. So it sounds like we're good. Mr. Banks, my thought is to bring Mr. Hairston just to the door here to let him know that we're set for trial on the 23rd, but I'll only do that if you say that's okay.
It's up to you, Judge.
Okay. Well, that's what I want to do. Can we just bring him right to the door? It seems like they got 12 deputies in the other courtroom. We only have 1? Okay.
And if you could just let him know I'll be out to see him this weekend, Your Honor.
Great. Ms. Simpson, you were able to do what you needed to with Mr. Colwell? Okay. Hey, Mr. Hairston. Good to see you. I've got your lawyer, Mr. Banks, on a Zoom right now. The prosecutor's here. I just want to let you know why we brought you over. Today is the call of the trial calendar. We're not starting the trial today. The trial will start, your trial is probably first out. Will start on the 23rd. So not next Monday, but the Monday after. Mr. Banks is going to come see you this weekend to talk more about that. And then he and I and the prosecutor will talk a little bit more next week just to make sure everything's ready. But I wanted you to know that unless something real surprising happens, your case will be number one on the list for Monday, the 23rd. Your family and Mr. Banks will get clothes ready, so you won't be appearing in front of the jury dressed like that. You'll be in street clothes and all that, but you should just be getting yourself ready to support Mr. Banks as he's representing you during that trial the week of the 23rd. So again, not next Monday, the Monday after. Does that make sense? Any questions for me? Okay, like I said, Mr. Banks will be out to see you this weekend. You can load him up with questions then, okay? All right, take care. All right, Mr. Banks, that is it. Thank you for dialing in. I will see you online next Friday.
Okay, thank you, Judge. Thanks, Ms. Willingham.
Thank you.
So that case is ready.
I do have an add-on that is expected to be a plea. Once you guys are done, I will hop back over to talk to Ms. Wood so we can get that ready to go.
Tell me which case that is.
It is Jerry Hughley.
Got it. Number 5 on our add-on. And you expect that to, okay, it says Ms. Smith, but it's Ms. Willingham.
Yes.
Okay, and
Yes, I do expect it to resolve today, so I'll be right back.
good. We'll see you soon. All right. Position 3 is Deontay Palmer. Ms. Rios, good morning. We talked about this a little bit on Tuesday afternoon. You're ready, but the forecast is if it's 3 defendants, this is not a case we can fit into that 1 week. Okay, but there's no reason why it couldn't be a backup to Hairston if Hairston didn't go, as far as you're concerned.
Yes, sir.
Okay, all right. Ms. Smith, are you going to be Mr. Abadi for a little while till he can be here?
I don't think so.
No? Okay. I bet you could do it. I don't know that we need him here. Do you need me to talk with Mr. Palmer? Do you want to talk with him? Do we need to keep him up?
I think we can, I already told him that he's probably not gonna be, I already told him what the court date was gonna be about. I did want to talk to Mr. Abadi about it. If we can work out.
Okay. Would you like Mr. Palmer to stay here, up here? What, he can go? Okay. All right. Position 4 is Amari Williams, who ought to be here. He is here. Mr. Williams? Okay. No, you're good. Just want to make sure you were here. You can take a seat. You want the other one back?
Yes, please.
Okay. Is Ms. Cabrera coming here today? Yes. Okay. Mr. Williams, we're going to sit tight till your lawyer gets here, okay? All right. And then position 5 is Antoine Owens, and that's Mr. Luemba's client. We'll hold for his report. All right. Wincliffe Adams. Hello, Mr. Tennis.
See this attorney on this case, but probably just gonna be an announcement.
So Ms. Smith is right there.
Oh, yeah, sorry.
You may have thought she was Adam Abadi because she's playing that role right now, but
Yeah.
that's Ms. Smith. That's the prosecutor.
He submitted the order. I can explain if we need to, but I think we emailed an order yesterday.
You did, and I was just talking with Ms. Nelson about that because the order's in the docket and I'm trying to get it out of the docket. And so we'll work through that. We don't, and we can talk about it if we need to, but that's underway.
As an aside, I brought a hard drive to get phone number from the state.
Okay, that was, Ms. Smith shared that the phone information was recently provided to the prosecutor's office. And I think Ms. Wood is bringing up, or has already provided a hard drive as well. So you'll want to be able to go through that. Other than that, though, Mr. Adams's case is ready.
Other than that, I mean, I need to go through the phones, but other than
Right.
that, yes. And he should be here in a minute. He texted me 13 minutes ago.
Yeah. So that'll be the key thing, is that he shows up.
I'll hang out here.
Okay, good. All right. Co-defendant is Julian Terry. Is Mr. Terry here?
He is all the way up. She sent me a text right away as well.
Okay, we'll hold for both of them. And Ms. Wood, you're ready on Mr. Terry, assuming the phone extraction isn't overwhelming, or is it, wait a minute, I need to now do some work on that.
That's correct.
Okay, got it. Nevada Twitchell, Mr. Twitchell, I see you. I don't see Mr. App. What's he telling you about being here?
Maybe later today, but.
How about next Tuesday, whenever it works for him?
He had a conflict and it would be here most likely after.
Okay. Yesterday, it sounds like it'll be after lunch. He needs to talk with the prosecutor. The prosecutor has explained this is a great backup to the case that we're going to do on the 23rd. So he's ready to try the case. That may not be where you want to go, but that requires Mr. App to engage.
We have an official, we have one more piece of investigation, how we did privately.
So you've connected with, I know when we were last here, Mr. App's colleague was here, and you understandably said, I mean, this is a nice guy, but Apt is the guy I've been working with. You and Mr. Apt have had contact since you were last here? No. Okay.
We scheduled a meeting for the 17th, so before.
Oh, as in 5 days from now? Okay, but that's before trial at least.
Yeah.
All right, it's got that going for it. It sounds like he's going to try to be here this afternoon. I'm going to release you until we have to stop at 12:30, and we're picking back up at 2:30. So if you could be back here at 2:30, you're welcome to stay. You don't have to go anywhere. But if you want to go explore downtown, you can do that. Be back here at 2:30. Okay? Mr. Denike, Ms. Rios, you are ready to go on that. You saw it's moved up one notch on the Emerson list, but my sense is that the other cases on there are ready. So this is another good potential backup to Hairston. Okay. But you were going to speak with Mr. Abadi about that case also.
Yes, sir.
Would you like to keep Mr. Denike here while you?
I think he would like me to talk to him.
Okay, I'll do that, but I'll wait for Mr. Abadi to get here. Carter Jackson shouldn't be here. Good. Okay. Charlie Daniels. Hey, Mr. Daniels.
Morning, Judge.
Mr. Majeski, how are you?
Doing okay, Judge. Once again, appreciate your accommodation.
Okay, no problem. Mr. Majeski popped by earlier this week, Ms. Smith, and indicated he needed to appear virtually rather than be here in person. I just said as long as Mr. Daniels was here, we were good with that. State's ready to go forward on Daniels? You've communicated an offer to Mr. Majeski?
Yes, I
And Mr. Majeski, you've shared that offer with Mr. Daniels?
I did.
Okay, Mr. Daniels, you want to go to trial? Well, I'm not sure. It's up to you. If you know what the offer is and you're not interested in entering a plea, then that means what we do is go to trial. You may want to give Mr. Majeski a call. You have his number? All right, Mr. Majeski, can Mr. Daniels give you a call?
Yes.
Great. Why don't you step out and give him a call? He'll drop off the Zoom and then we'll talk again.
Thank you.
Ms. Hurd pled Billy Lowe? Well, just in case he came in, never know. Okay, Derek Flagg in custody.
should be able to do that, Judge.
Both cases?
Yes.
Great. Alexis Scott. Hello, Mr. Hines.
Good morning.
Well, where's Miss Scott?
She is not here, Your Honor. I reached out to Ms. Nelson asking if she could be on Zoom because her mother and her partner are not available today.
Okay.
And we weren't sure if we needed to show up since her behavioral health treatment court is still pending.
So I needed an update from you on that. What have you heard from did she have an intake interview?
I don't believe she has yet, but I've been in touch with the coordinator. They have the referral, and they said they've begun the screening process.
Okay. And what did they say? They'll reach out to her. You gave the intake team her contact information?
Yes, sir.
So they don't need to work directly through you. They can contact Ms. Scott?
Yes, Your Honor, that's my understanding. They have all of her information, her address, her email address. And I've been in communication with them, so if they need anything from me, they know. And I sent them her diagnosis, and all of that.
Okay. Let me. Send them an email, see what we can find out, the intake folks, about if they think it's gonna take 2 weeks or 1 week or what, so we all leave here knowing what to expect.
Yes, Your Honor, and just so you know, I was in another division yesterday, and that judge mentioned that their BHCC is backed up on the interview process.
Okay. Ms. Smith, have you checked with Mr. Abadi to see when he could be here?
Yes, I have, I haven't heard back yet.
Okay. There he is. Morning. All right, I sent the email. If you don't mind sticking around, Mr. Hines, for a little bit in case they give us a quick response.
Yes, Your Honor, absolutely.
Okay.
Thank you.
Is that your one case for today?
It is, Your Honor.
All right, I won't, if you've got other stuff and it's been a few minutes, just reach out and say, couldn't you just email me? But in case they say, hey, it's gonna take 6 months, we may want to talk about something different. Are you expecting Ms. Scott to appear on the Zoom? I don't know. There are a couple that are just listed as phones and not names.
So I have to, my apologies for that, Your Honor. I need to get the link if that is okay with you. She's on standby.
Okay.
It would be very hard for her to get here with Xavier, who you met 2 weeks ago, but she's on standby for Zoom or to come in.
No, Zoom's fine. Ms. Nelson's going to send you the link and then she can pop on and we'll figure out what the situation is.
Okay, thank you so
All right.
much.
Jamal Lewis.
Morning, Judge. Judge Sperling, on behalf of Mr. Lewis, I'm covering for Attorney Ross Gordon. We should be able to resolve that matter today through a negotiated plea. If you could please hold from a report to allow me a chance to speak to the prosecutor, please.
Sure, is that Mr. Lewis in the back?
Yes, sir.
Excellent. Okay. We will do that. And you are going to be Ross Gordon all day long.
I'm gonna be Ross Gordon all day long.
Okay, thank you.
Thank you, sir.
Ms. Smith, that had been a referral that didn't work out, or you and Mr. Sperling are going to talk about this?
I'm sorry.
Number 22, Jamal Lewis,
Oh, yes, that number request was denied.
denied. So you and Mr. Sperling do need to talk. Got it. Thank you. Rashad Shepard. Tremaine Scott. is here. Good morning. Ms. Rios?
And I didn't talk to the state, the state you can work something out. I'm not sure yet, so.
Okay, Mr. Scott, your lawyer is gonna talk a little bit with the prosecutor and we'll figure out if you're working your case out today or if I'll see you a week from Monday, okay? Jesus Enriquez Perez.
Good morning, Judge. I'm here on behalf of Mr. Enriquez Perez. He is in federal custody. I see the prosecutor just walked in. You could hold from a report as well again, please.
We'll do that. I think we found him. You found him. He's at Dayton, which is Lovejoy.
He's actually in federal custody at Lovejoy.
Right.
So I can talk to her.
Okay. And he was just sentenced, so hopefully we'll be able to connect with him before he goes further away. All right, if you'll speak with Mr. Sperling and then let me know a plan, we can see if there's a way to connect virtually with Lovejoy or we can borrow him. We'll see. Okay, thanks.
Thank you, Judge.
You bet. Teresa Smart.
Good morning, this morning, to Attorney Chantal Sherry. I think we'd also see the pre-trial with the state. I've been speaking with Ms. Williams. Ms. Williams.
Ms. Williams is in trial, I think, still down the hall. And so someone I think was going to be here, maybe Mr. Pennington, but I'll let the prosecutors let me know who is going to stand in for Ms. Williams. So there is someone for you to talk to. Okay? You bet. Ms. Smith, any thoughts on who will sub in for that unit?
Give me 1 second.
Okay. We have an add-on calendar. Kendrick Wilson, Ms. Wood says that's on for a plea?
Yes, sir.
Okay, and that's still the plan? All right, and then Kanye Willingham, I think I saw Mr. Rhodes, there he is. We're gonna do a bond hearing. I think he may still be downstairs. Has he not come up? So he's in the building, he's just not up here yet. So we'll do that. Eugene Roberts requires Ms. Cabrera. We don't have her yet. That's 2 positions. And Jerry Hewley will be a plea. Ms. Willingham needs to come back for that. Is that correct that it's a plea? Okay. And then we have another add-on, Malik Henderson. Any idea who's going to? I think that's right. I don't have any probation documents, but my recollection is he had a hiccup with probation. Okay, so will you be handling it? Okay, have you spoken with Mr. Henderson yet? Yes? Is he not upstairs? Yeah, for some reason, his situation is complicated and we have to bring him up special. Thanks for being here. So we should prioritize that since the officer's here. But that may be complicated. I guess he could come straight up and in? Okay, we may do that. We'll make a plan. And then Kenny Askew has a revocation as well. Is that you also, Ms. Rios? You ready on that? Okay, great. That's it. Did anyone not hear their name called?
Mr. Adams is here.
Mr. Adams, all right. I think unless you need to talk with Ms. Smith, you guys are good to go. Just check in about the filing you sent, but we're working on that, okay? Oh, and you need to hand over your hard drive or whatever you're gonna do. Okay. Ms. Smith, anything else on Mr. Adams's case? Okay. Anyone else not hear their name called? Okay. Okay, great.
Judge, I'm back whenever you get back to us.
Well, let's do it. Mr. Daniels, you back in here? All right. Let's just be clear about where we are with this. Ms. Smith, you're having to bounce around a lot, but in the Charlie Daniels case, what's the offer you conveyed to Mr. Majeski?
10 years, he served 1 with the balance probated.
Okay, 10 serve 1, balance probated. Mr. Daniels, is that what you and Mr. Majeski talked about? No? Mr. Majeski, you shared a different offer with him?
No, that's
Oh, okay. That's my question was, did you and Mr. Majeski talk about the offer? Answer is yes. And then your secondary answer is, and I don't want it. Okay, so you want to go to trial? Okay, that's what I needed to hear. I will add you to the list. Mr. Majeski, anything else on behalf of Mr. Daniels?
No, Judge, but just for planning purposes, I know you like to have all your angles covered. Down in Henry County, I got a report on the 23rd. I'm not sure if they're going, but there's 2 older cases. I can keep you updated about that when I get the information. I just wanted you in the state to know about that because
Okay. If you would send an email to Ms. Smith and Ms. Nelson and me with those cases, that'll be our reminder that we need to check with Henry or hear from you about whether you meet down there for trial versus this.
I will, Judge.
Okay, sounds good.
All right, thank you, Commissioner.
Anything else on the Daniels case? All right, Mr. Daniels, you will likely need to be here on Monday, the 23rd for trial, but Mr. Majeski will keep you posted. If he is stuck in trial in another county, I'm not gonna have you show up because we can't go forward without your lawyer. But if he is not in trial in that other county, then you and he will probably need to be here on Monday, the 23rd, ready for trial. Okay? All right. Thanks, Mr. Majeski. You're good to go.
All right, thank you, Judge. Have a good day.
Ms. Cabrera, you got several things. So Mr. Williams is here. As you and I and Mr. Abadi discussed, in theory, this could be a backup for the this upcoming trial week, but it's only a week. And so that might not be long enough to try this. And then I said, hey, let's do it in March, but I think you have leave for our March calendar. Yeah, so we'll have to see when we can get this locked in. Then yep,
Several things.
you do. I just thought, okay, you don't have anyone else on the trial calendar. But you do have Mr. Roberts, who is here, who's got 2 open cases and a revocation, and it's listed here, highly possible plea.
Yes.
Do you need to chat with him?
I do.
Okay. And did you have anything else? Those were the only,
Yeah,
Case-
that's the only thing, but I want Mr. Williams to step out and meet me. So I
Okay.
can speak with him and then.
great. Why don't you talk with Mr. Williams? You can release him. You don't need to come back in when you release him. And then it would be great to take care of Mr. Roberts when,
I think he's upstairs. So,
if Deputy Gordon says he's upstairs, he's upstairs. I know he's anxious to have him downstairs, so if we can do that, that's great. Okay,
do you want, plea paperwork done for?
Mr. Roberts, we can just make it on the record.
Okay, all right, thank you.
Uh-huh. All right, while they're doing that, is there anything we could knock out right now? I know lawyers need to talk. Mr. Sperling's going to talk with Ms. Nix, et cetera. But Mr. Abadi, now that you are here, I think Ms. Rios wants to talk to you about her 2 cases. I think that's it. You told me you're ready on Denike. If that's back up to Hairston, everyone on Hairston said they were ready. I think that's it for, and Mr. Twitchell was here. I excused him till 2:30. We got to stop at 12:30 and we'll pick back up at 2:30. Mr. Apt is supposed to be here this afternoon. So if you don't mind checking in around 2:30, you can reach out to Ms. Nelson or just poke your head in here. If Mr. Apt is here, I explained to Mr. Twitchell he needed to be here. All right, thank you. So Ms. Wood, if there is a plea you want to do now, or if you need to talk with some people, I could just step off the bench for a few minutes so people get organized and then come back out.
If I can get in the back, I'll speak to everyone and then we can start rolling.
Okay. Why don't I talk with Deputy Gordon about how we're going to juggle all the pieces? And Mr. Hines, I don't have an email back yet from the intake team. I don't want to keep you here for that. I'll just let you know what they say.
That's fine, Your Honor. Just so you know, Ms. Scott is on the Zoom.
Oh, she is. Great.
Yes, Your Honor, and
yep.
I can stick around or look out for an email at your convenience.
Okay, there she is with a very small child. So it's really up to you. I will send an email to you and Ms. Smith so we know I'll just forward whatever the intake team says. I just want to make sure it's squarely on their radar. Sometimes I reach out like, no, we don't have that. We're not sure. Just because you didn't use the right channel or who knows what. So I'm not doubting your efforts. Just want to confirm them. And then if they say we'll know in a few weeks, then we'll just relax for a few weeks.
All right, that sounds good to me, Your Honor.
Okay.
Excuse.
Yes. Thank you, Ms. Scott, for dialing in. You are free to sign off.
Thank you, Your Honor. Have a good one.
All right. Bye-bye.
Thank you, Your Honor.
All right. I'll be back out in a couple minutes to see what we can do. Deputy Gordon, let's talk juggling.
Yeah, well, the top. Check.
Yeah. Oh, yeah, I'm gonna give you 179. Yeah. There you go. Thank you. We can turn around. Which is a lot of things that he's holding their power. I know we can. Yeah.
I know you're gonna have some. I would recommend to speak. But you really want to part of this. Yeah, I would. Who's here? Yes. Oh, good. I'm trying to get out for something. Oh, yeah. I'm gonna do it. Will you let him know that you're in?
Yes.
Miss, who you guys in? Who?
Flag, Wilson. Where, what?
He's down. I didn't bring him.
Oh, okay. Wilson and Hughley. Can I talk to him?
Yeah. Hey, you guys know, so.
I'm just saying, while you on probation, violated.
Yeah.
That's what you are.
Yes. So I guess I'm getting. You don't have to work tomorrow, right? You're supposed to work Friday. I had a motion. Will, okay. You get out
No, you can't go do, you know, like, unless you gotta go, so I'm like, right, you also, keep running, get right, just keep my move. Yeah, but it's all good, right? Yeah. Yeah. I'm gonna be big burn. All right, bro. Enjoy the cheer, bro. Yep.
Okay, give me 1 second. I should be down. Just give me Y'all keep the other calendars.
Is the dread. It's what we're going on, right? That I'm not since Kanye been going to their program, he has been these cases about something older. Also thinking I have talked to him, you know what I'm saying? I talked to the person. You don't want Christian to come, you want Christian to look at it.
Good morning.
I'm gonna go down to, Dr. Schwab.
Okay, let me make sure I'm doing. Okay. Hello.
Hey, good morning.
I'm Shirley. How are you?
Good, Leah, nice to meet you.
Hey, I know that you've been talking about your works with me.
Yes.
Okay, so I've got, here's my problem. I just literally did one of these. I literally just did one of these. I know that you was applying for PT, right?
Yes, sir.
For PT. And here's the thing that my perspective is from students that are doing. Okay? If this was an ISO case that we should have gotten indicted for ISO from the get-go. And if you were reducing or dismissing the ISO, just because you're negotiating with me, then I will make this request. I will just say, take this from that, and then I'll say,
They're already looking.
Actually, it wasn't.
Okay, we're good to go. So,
Somehow.
he doesn't have any kids.
So,
Yes.
Let me show you. I don't know, this is a super nice kid. Because I found a letter.
Right.
Because of this contract, because of how.
Thank you.
He's not. Is just Orlando Circular.
Oh, very much so much.
Pictures from the.
I'm just.
If he was actually arrested for initial, she's the one that's not. I wouldn't be asking for this, I would be saying, thank you so much. But knowing. He's too much work. Looking people up all day long. And I just literally did this perfectly. It was, then one of the charges was outside the guidelines, prosecuted as a local indictment, we accused it, and I'm only going to felony in the crime that he did. That's the reason about it.
I understand. I understand. If we have taken. Because that's what I talked to Ms. Brown at my work. That. And then I say I'm sure people go to trial county, or prosecutor trial county, cash back and forth.
This is incredible. That page, so I extremely
All right, give me a second.
Thank you so much.
I usually go from that. And then that's. Try. Or. Yeah, I think that's it. You recommend like this. I really try. Which one's still like? She will be on my child. Stand up and then. Hey. Oh, every chance I can. Something. Sure, so next. I would. Yeah, sorry. Not going yeah, that's a concern. They just want to know if they can get coverage from, I guess, the county and us, just a month.
Man, city work.
So the one thing, Mr. Roberts is gonna be pleading and I'll come out as soon as you wanna do that.
As soon as we can get a second deputy, I'd love to do 100 things.
So that we don't, kind of compare and discuss it.
Okay.
Mr. Williams, I had filed a bond modification, motion for, just to see if the county, or I don't know how they cover the ankle monitor. His family has been paying for the ankle monitor.
Oh, it's been a self-funded one.
Correct, the whole
Okay.
time. Remember, he's with his grandmother, the grandmother is ill, and there's some other family expenses.
Okay.
So the request was.
To shift it to a county funded. Okay. And what did your colleague on the other side say? It's helpful. Okay. All right. I will, we'll sort that out today. I'm trying to get all the pieces in place to move some of these things along. There's one of the pieces we needed.
But I didn't know if you wanted to keep him, but I had made him come back.
No, I mean, I don't mean to keep him here either. I won't keep it secret if I modify the bond. The only thing that would be changing would be county funded versus family funded. Okay. I will look at that bond, and Eugene is ready to go. Yes, ma'am.
Mr. Hughley is for certain going to be a plea. Ms. Smith is gonna be prepared to take that. I'm gonna go over and continue prepping for Mr. Harrison. And I did speak with Ms. Williams, someone from the prosecution.
Oh, right, because someone needs to talk with Mr. Sperling.
Is taking a plea.
Okay.
Judge Cox.
Okay.
He will be over as soon as he's finished, and I have notified him that defense counsel is waiting to speak with him.
Excellent. Okay, and you told him which defense counsel it is. Okay, good.
And with that, Judge, may I be?
Yes. All right. We're going to do Malik Henderson. I think that's who we brought up.
Can I make a very quick announcement?
Yes.
Mr. Terry has arrived, Judge.
Mr. Terry, where are you?
Right here.
There he is. Good morning, Mr. Terry. What else about Mr. Terry?
I've spoken to him. We're gonna be ready, subject to the cell phone.
Okay.
Stuff, and just asking that he be excused.
Sure. So, Mr. Terry, two things. One, you were late, but that's okay. Traffic, and your lawyer told me you'd be on your way. Two, she just received a bunch of new information from the state. It's just cell phone extractions. And so Ms. Wood obviously needs a chance to look through that to see if there's anything of interest that may occasion a delay, but otherwise, your case ought to be ready to go. I've got it on the short list for trial this calendar, which is a week from Monday. But I'll be checking with the lawyers to see if this recent delivery of the cell phone extraction is something where the lawyers say, we need a little more time to process that. So you should stay in touch with Ms. Wood because you may need to be here on Monday, the 23rd for the trial calendar. Any questions about that?
Not exactly, no.
Not exactly. I mean, you have lots of questions for Ms. Wood, but if you got any for me, now's the time to ask them. I might not be here next time you want to ask them. Okay, sounds good. If you are told to be here on Monday, the 23rd by Ms. Wood, that's one where you don't want to be late because there'll be jurors waiting and they're going to see you come in late and then you don't want jurors to be frustrated that you were late. Okay? Excellent. Then if you want to talk to Ms. Wood some more, you should sit tight. I'm not asking you to stay any longer. Great, she's right there. Mr. Sperling.
Yes, briefly, I'm going to make a quick announcement from Jesus Enriquez Perez.
Yes, sir.
This is the gentleman that's in federal custody. I've talked to the department. We are going to try to negotiate. At this point, I think I would just ask for the case to be continued based on the posture of him being in federal custody. He's going to be in federal custody until May. Prosecutor is going to get back with me to follow up on our conversation. That would be my humble request for today.
Do we know what's next for Mr. Enriquez Perez after May 30th? Is he going into Bureau of Prisons? Is he going into another country's custody or is he walking free?
Well, I don't think he's walking free.
Okay.
I think that what's going to happen is his federal prison sentence will expire in May, after which he will get picked up by ICE. He will be in ICE custody for 30, 60, 90 days, and eventually he will get deported back to his native country of Mexico. He's
Got it.
definitely not working out of jail.
Okay, but that May date actually is consequential for us because we may lose the ability to interact with Mr. Enriquez Perez. So we want to keep the pressure on constructively. What do you propose, Ms. Nix, as the right next calendaring for Mr. Enriquez Perez?
If you could put us on the March calendar, I think we would be able to get something together for you.
Okay, so the very next calendar, and I appreciate you sharing the location. So I guess Ms. Nelson and I will work to figure out if there's a way to either get Mr. Enriquez Perez to appear virtually or actually brought over here. Are you able to have access with him directly?
Yes, I do federal work, so I would.
Okay,
Once Ms. Nix provides me, if we can reach an agreement for better or for worse as to what we're going to do, I will go visit my client in the federal facility.
Okay,
And obviously, I will know well in advance what his position is going to be.
Okay.
I'm just gonna go ahead and wait for the state to let me know where we are. And based on that, I will go talk to the client. And if it's going to be a trial, I'll let Ms. Nix know so that we can go ahead and make preparations. Just in my experience, it would be difficult perhaps to produce him from federal prison. But I would suggest we would produce him for plea or trial, do it right at the cusp of when he is about to go to ICE custody.
okay.
That would probably be a lot easier to produce him.
We have pulled off a couple times a virtual appearance. If it's going to be a plea, we've been able to do that. So I'm going to trust you two will keep talking. And if it is something, even if it's non-negotiated, if it's going to be a plea, we might be able to make that work independent of that May deadline. But we'll see what happens. Okay, got it. Now you had a second case.
I've talked to the prosecutor. I'm waiting for an answer from her. You can just hold my report.
So you're not leaving. I just want to make sure. Okay, got it. Great.
That was my only.
But you are leaving.
That makes-
Yes. All right. Sorry, all these people need to make announcements. Let's bring Mr. Henderson out, please. Good morning, Ms. Rivers. How are you?
I'm Judge. How are you? I'm doing okay.
Good. We are going to go on the record now with Malik Henderson. It is 22 SC 183095. And Mr. Henderson is here because of a probation issue. I signed a petition and a related warrant that alleges that Mr. Henderson is complicated, and we're going to work through it. But as I understand it, Mr. Henderson was supposed to go to the PDC, the Probation Detention Center, and was released in error from the jail. He had a 60-day stint at the PDC. He was told to go back to the jail to be transported, and he didn't do so. His officer again said, "You need to turn yourself in," and he didn't do so. That's what was brought to me, that we now have someone who was released accidentally, not that he escaped, but then wasn't going back to where he needed to be so he could have the PDC sentence. I don't know what's behind the PDC sentence, but that's not what's being challenged here. There's a 60-day PDC sentence that needs to be served. And I'm sure the officer, or you may even know, what happened with Mr. Henderson's probation that resulted in that, because that wasn't his original sentence. We had his case dealt with a long time ago. But we're working through this. Why didn't you come back when your officer directed you to do so? And I'm assuming that's Officer Adams and your Officer Adams.
Yes.
So we've got all the people we need here. So I'm going to start first by saying good morning, Mr. Henderson. And then ask you, Ms. Rios, as now counsel for Mr. Henderson, is he stipulating to this but with explanation, or tell me what?
Stipulating with explanation. Should I go ahead and get?
Please, and I know you sent some text messages. I haven't had a chance to read them yet, but we'll talk about them. If they are texts between your client and Officer Adams, we've got everyone here, so we ought to be able to work through this.
So my understanding is, going back, he was initially violated because he did not update his address because he was evicted. His address was going to be with his mother, who is here, Ms. Henderson. And he was in the process of moving his stuff out with her, but then the probation officer said, "Too late, you're violated." He was in jail. He has had some issues with the jail, people attacking him. So he ended up signing and agreeing to go to the PC, what's it called? PDC, for the 2-month stint. He then was accidentally released, and then he didn't go.
How does that happen? Yeah, you didn't release him, but he just one day they're like, "Hey, you can go." Basically. Okay.
So his concern, which I think is a valid concern, was if he just goes back, there's no record of him. They tell him he was released, and that ended his, I guess, time in the jail. When there was a warrant, he actually went back. He wanted some documentation so he just wasn't lost floating around in the jail. And my understanding, based on the text messages, him Mr. Henderson and his mom have communicated with the probation officer, constantly letting him know what was going on based on a text that I saw. Speaking to his mom, she seems very communicative and just very like on it, on top of everything. So I'm just like kind of confused with how this even happened with him having a mother who's so on top of everything. But it just seems like this was a miscommunication, and he hasn't had any new cases, Your Honor. He's doing, I sent you that he's in school, he's in audio school. He is trying to work on school, trying to work at a job. He has no kids. He's not out here just, causing trouble. I don't think it's appropriate for him to be going to prison where he's in danger, or that's why they keep having to have him separated, because he's in danger. I think did you have a head injury?
Yes, ma'am.
Yeah, so for a non-violent person to be going into jail when they have to deal with possibly getting seriously injured based on a technical violation, because usually technicals aren't even handled in this situation like this. Well, in this way, usually that it seems to be going to the non-complex probation load. But I'm asking for him just to have time served and not have to go into custody. And I know his mom wants to speak.
Okay, well, we'll get there at the appropriate time. But if there was already a decision made by either a POM hearing, although I don't think they do those anymore, or a magistrate or someone said, you've got a revocation, but you're going to do that at the PDC, why would I unwind that now because of the mistake that your client was released? I'm not following. It seems like we need to get Mr. Henderson to the PDC to do the 60 days. There may be a request for there to be more than that from the state or from probation because of the failure to turn self in, if that's really what happened. But I'm not following why, because he had the windfall of being accidentally released from jail, he shouldn't still have to do whatever sanctions someone else already said. You got to do 60 days.
I understand, Your Honor, and I explained to him that since he's signing, there's might not be anything we can do about that.
Okay.
But I do understand probation is asking for additional 6 months, which I think that is very unfair.
Okay. All right. Your request is, the most aggressive request is just let him go home.
Yes, sir.
Short of that, it's, hey, there was confusion. Jail's not really where he wants to be. So let him do his 60 days and then we'll reconnect.
Yes, Your Honor. And my understanding is because he already did a month in jail, but that doesn't count towards the.
I don't think so, but I'm pulling his case up so that we can see what was going on. Although I suspect with Officer Adams here, he's going to be able to make pretty clear, here was the series of events. Okay. All right. My thought is, unless it starts getting complicated, Officer Adams can just say, here's what happened. If we need to put him under oath and you need to question him, I'll certainly let you do that. But I'd like to keep it informal right now and just hear from Officer Adams what led up to the petition that he presented to me.
Yes, sir.
And I'm not forgetting that Mr. Henderson's mom wants to speak as well. We'll cover all those bases. And we have a prosecutor. But I'd like to start with you, Officer Adams. First, thank you for being here. Can you walk me back to why Mr. Henderson was going to need to spend 60 days at the PDC?
So, Judge, he moved without letting me know. Evicted, anything like that. I spoke to him on October the 23rd through video chat, and we talked about everything. And then I attended a field visit to his residence on October 28th, and the property manager asked me where I was going. She knows my face, she knows where I'm going. But this time she asked me where I was going. I told her I was going to see Mr. Henderson, and she said he does not live here in Florida. And the months prior to him being evicted, Judge, I've been in communication with him, like, hey, how's everything going with the apartments? How's everything going with your eviction? He was keeping me updated, like, hey, we're trying to file something with the government to, try to see if I can pay my rent and catch up. I'm like, okay, keep me updated. So I believe 5 days went by without him letting me know that he moved. So that's where his original warrant came from.
Okay, and then was there a POM or what proceeding occurred such that someone decided, whether it was you or a supervisor, and Mr. Henderson had a chance to say, great, I waive a probation revocation hearing that led to the 60-day?
Okay, so, we handled his violation. He was sentenced under POM.
Okay, I think I found it. So it looks like in December of last year, this is not a familiar document to me. It says options waiver and imposition of sanctions. Okay, and it's got Mr. Henderson's signature and, okay, and it says you're going to the detention center.
Right, so
Okay.
after two POM waivers, I have to pretty much try to send you to the probation detention center. The first time I got him out of jail, well, a previous officer got him out of jail for failing to enroll in sex offender treatment. So he spent 6 days in jail and we got him out as a probation officer. So then he came to under supervision under me and he was terminated from sex offender treatment. So I got him out of jail after 14 days.
So those are his two.
Two POM waivers.
Okay,
So this third one, which is why he moved without letting me know. I had to basically up his sanction to go into the PDC.
okay. And he signed it, I see it, and that's got us to now this is why you're in custody. He was released in error. Walk me through your recollection of what happened when you learned, wait, you're not in jail anymore. You're supposed to be waiting there to get to the PDC.
So my chief reached out to me, she said,
And that is,
Chief Barnett.
okay,
She sent me an email and said he was supposed to be transported, because we're all on email. He was supposed to be getting transported to the PDC on, I believe, a Monday. I believe my chief reached out to me on a Friday and said, hey, just make sure everything is good to go. But it was after hours, so she checked it and it showed that he was actually released from jail.
okay,
So I didn't know that. So we got in communication with his mother and Mr. Henderson and say, you were actually released in error. You were supposed to go do 60 days. And you need to go turn yourself back in, which of course he didn't. So I, reached out to him again and said, hey, you need to turn yourself in. And he failed to do so twice.
okay, got it. And then ultimately, he's in custody now. Did you have to go get him or did he ultimately turn himself in?
He ultimately did turn himself in.
Okay, got it.
We were going to go get him.
Okay. And did he turn himself in by reporting to probation on Memorial Drive or going out to Rice Street?
I believe he turned himself into Rice Street.
Okay.
Yeah.
All right. Thank you. And what is your recommendation as a result of how all this has played out?
So my recommendation is 6 months.
Okay. Is that 6 months at the PDC or it's forget about the PDC, revoke 6 months?
We can really just forget about the PDC because now we're back in front of the judge and we're going through a full probation revocation.
Okay.
So that'll be at the jail.
Okay. Got it. Thank you. Ms. Smith, we heard a lot from Officer Adams. Tell me what the state's perspective is if you're handling this. His case originally was in one of the specialized units, but we're not getting a lot of those folks in here today. So I'm looking to you.
Yes, in this case, Your Honor, going through all of your been listening to both sides, I believe the state is going to be asking for the courts to revoke 60 days in this case and to maintain the balance.
Revoke 60 days.
Yes.
Okay, and then reinstate the balance.
Yes, Your Honor.
All right. Okay, back to you,
Yes.
Ms. Rios. I'm happy to hear from Mom. I'm happy to hear more from you. I know there are the text messages, but what did I not learn all about? I've heard how Officer Adams experienced this. What pieces are missing?
I think I said everything that I understand. Maybe his mom, Mr. Henderson, if she wants to, do you want to add anything?
Okay. Ms. Henderson, you're welcome to, you don't have to add anything, but if there is something more that you want to share, I need you to come up to a microphone so the court reporter can hear you.
Yes, sir. Just up here.
No, I think probably that one right there. We'll just bend it towards you. Sure.
Come on, there you go.
Yes, ma'am.
All right.
So I just want to add that Officer Adams and we text because he knows that Malik he's a young adult. He's in a bad financial space. When he initially got violated for the therapy thing, the probation officer had to go get him because the therapist did not communicate that Malik did take all the evaluations, and he was just waiting for the therapist to give him he was waiting for the therapist to give him his treatment plan. We kept texting, calling the therapist to get the treatment plan. Then he eventually let the probation officer know, like, oh, he did take the evaluations and stuff that he was supposed to take. I'm just needing to give him his plan, right? So they got him out because they realized that it was an error, that he did in fact do the evaluation, intake eval and stuff like that. I paid for it. So I know he did it. I'm like a helicopter parent. So that was the first violation.
The apartment that I'm hearing about that Mr. Henderson was trying to keep and was trying to overcome the potential eviction, was that an apartment with you or that was his own space?
No, Your Honor, that was his own space that he was trying to maintain. However, once Officer Adams violated him for missing a few of the therapy sessions, he was sitting in Fulton County Jail. He lost his job. They repossessed his car. And once he was released, just trying to fight to get some stability. And then I know that Malik was telling me that he was trying to communicate with Officer Adams. It may have been a few days later, but I feel like people are depressed. Like, people get depressed. Malik went through a terrible situation, almost being murdered in Fulton County. He has some PTSD. He has some things he needs to work out as a young adult. Some imposed violence that he didn't grow. He grew up in Virginia Highland, so that he's not grown up like that. So of course, something being imposed on him like that was traumatic. And I feel like my son needs the space to be able to heal from those things. Like, even this time in jail, it's just back to the drawing boards, where I have to get him placed into a private space by himself to keep him from getting harmed at the jail. It's just too much for me as a parent, and I feel like it's too much as my son as a young adult. However, I'm gonna stick to the point. So when he was being evicted, he let Officer Adams know that he was being evicted. Officer Adams has my cell phone number. He calls me about everything else. After a few days after Malik was evicted, Officer Adams said that he went over to the apartment. He confirmed with them that Malik was evicted, and he left the property and then went and filed the warrant to lock him up. I felt like that the 60 days was a little heavy for a violation of address when there's people out here robbing people at gunpoint at the murder Kroger on Ponce. But Malik told me that because Officer Adams came to him saying, like, in essence, like he didn't have any other rights, like coming to court in front of you, which I would have had rather him come here instead of going to a palm hearing. Officer Adams came and was like, oh, well, from my understanding, you might as well take these 60 days. If you don't take these 60, then you're more than likely going to get 120 at the hearing for the palm hearing. He did not let him know that. I don't think he informed him. I'm not sure. I'm not going to say that solidly, but from my understanding, didn't inform him that he had the right to even come in front of you, because I would have just recommended he come here instead of taking 60 days for failure to update an address. When Officer Adams had my gate code, I gave Officer Adams the gate code. I gave Officer Adams the address. His supervisor, Barnett, we speak. As soon as Malik was released, Malik texted Officer Adams' cell phone the address. And I was like, I think something's wrong, so I don't think he's supposed to be out. Which I was happy to see my son, because like, who wants their kid to get murdered at Wright Street? So anyways, long story short, Malik was in full compliance. He went down to the probation officer within the time frame. He is trying to finish college so he can get a career. Like, Malik is so unstable because he keeps having to go into jail behind minor things that are major, because you still have to follow the rules. But I think that he has learned his lesson, to be quite frank, because yesterday room flooded with urine because the jail was flooding. It's just a lot. And I feel like as a young adult, for him to have been going through this since he was 15, all the way up until now, it's just a lot on a human period. We're all working class people. Let a bill get behind. We somewhere crying, wondering where the money's going to come from. Imagine being a young adult, no children, trying to pull your life together, and then you don't even have a moment to breathe, to be depressed. So Malik informed me that he felt pressured to take the 60 days. And then when I found out that you had dismissed the warrant, I'm like, well, there's no active warrant. So they want you to just walk into the jail unaccounted for? That's weird. So then Officer Adams told me he was going to try to get another warrant. From my understanding, he came and said he didn't know where Malik's whereabouts were, which is not true. I sent you the information showing that Malik, he went and he turned in all his information and everything he's supposed to do. And also, if you would just please take into account that every time they violated Malik has walked into that Fulton County jail without anybody having to chase him down and follow him down. And I've been in full communication with Officer Adams' superior, and she was like, okay, I'm gonna give him a court date. She was like, tell Mr. Henderson to turn himself in. Then Officer Adams texts like, oh, come down to the probation office. I forwarded that message to his superior, and she said, no, he's not supposed to go to the probation office. He's supposed to turn himself in. Malik then turned himself in. He has walked into that jail every time knowing that his life is in danger.
Okay.
And so I hope you can please take that into consideration. I really want my son to have a chance to get his life together.
All right. I
Thank
appreciate
you, attorney. Thank you, everybody.
All right. I appreciate you being here as always for Mr. Henderson. Mr. Henderson, is there anything you want to add?
So not really. I think she pretty much covered it.
She covered a lot. A few things, Mr. Henderson. One, I think it's important, and Ms. Rios is very effectively representing you now. She did not represent you when you pled. You were indicted for an offense that would send you to prison for 25 years with no parole. And the district attorney's office worked closely with your lawyers, plural. You had a number of lawyers. They were very effective advocates, and you were given a pretty remarkable second chance with the state's blessing, what you were allowed to plead to. So of all the folks I work with here, you ought to be on a pretty short list of, I'm going to dot every I and cross every T. And if probation needs me to turn left, I'm going to turn left. And if they need me to show up at 8 a.m., I'll be there at 7:55 a.m. I'm hearing you and your mom and your lawyer say, hey, come on, give Henderson a break and this and that. You got some phenomenal breaks to be out, to be back in school, to be trying to set up your own apartment, et cetera. I don't want you to lose sight of that because what I'm hearing is, man, probation's on my back and this and that. And it could be that it's the Department of Corrections on your back for 25 years, and that's not how it played out. And I'm not questioning that decision. I think that was the right outcome. But I'm a little worried that you're not embracing that opportunity that you were given. So you need to figure out a way to stay compliant. The requirements are not all that extreme. Mostly it's let people know where you are. And if your circumstances change, you let them know that your circumstances change. But you've had a few hiccups already, and they aren't major ones. To your mom's point, you're not running around, you didn't run someone over with a car or beat someone up with a baseball bat, but you've got to be the kind of person who is at the other end of the spectrum of just like, he's baking cookies for probation. He's doing all the things and then extra because of the opportunity that your lawyers and the state created for you to make that original charge go away and be reduced down to what it was. That's my sermon to say you have not much leeway. And I get it that going back into custody is not something you're particularly inspired about. You don't get treated well there because some folks know what the original charges were. I do think PDC is a safer location. I want to wipe the slate clean. And what I'm going to do is impose, I do find that you violated the terms of your probation. And I don't know if I need to set aside the Palm thing. We'll talk about this just so it's structured the right way. But I am going to require you do at least 90 days at the PDC. When you come back out, you'll be on probation. You need to let folks know where you're staying. And when you move, you let them know when you move. But you've got to be hitting on all cylinders until you've got a few months or a year under your belt of, look, Henderson's doing the things he needs to do, and probation backs off. They got other people they need to worry about. I don't get the sense that you are out there as a menace, but because of what you were charged with and what you pled to, you've got a greater responsibility to show probation that you're reliable and you can be found when you need to be found and you're taking care of the business you need to take care of. If you've done that therapy and that's taken care of, then it sounds like you can start focusing on you. And if it's going back to school or getting a job, you can do that. But we're going to clear this up with that PDC stay. And when you're done, you just need to make real clear, here's the best way to reach me. And mom is a useful resource, but your mother is not on probation. And the fact that Officer Adams can find your mom isn't how this works. He needs to be able to find you. And when he calls 1-800-MALIK, is you on the phone and not your mom. because you are an adult. You're a young adult, but you're an adult, and you're the one who faces consequences if probation isn't working well, and not your mom. And so she can help, but ultimately, officer needs to find Malik Henderson and not mom or someone else. Does that make sense? How do we structure this, Officer Adams or Ms. Simpson? Because there's this POM thing in there. I don't mean for it to be 60 plus 90, it's 90.
The special condition, for the, structure to, the palm sanction to be removed.
Okay, so the POM sanction will go away. The revocation will be 90 days PDC, and then reinstate probation. Officer Adams, I know you get shifted around. What's the likelihood, just so Mr. Henderson knows, who do I need to call when I'm out to let him know I'm out, that you would still be his supervising officer when he gets out?
Yes, he can call me.
Okay, even if you're not, he can call you and you can say, hey, I got rotated and it's now Steve Smith who's doing it, but.
Yes, and he can report to the probation office, as soon as he gets out, and we'll get him squared away.
Okay, so standard within 48 hours of release, be at probation. Are you apt to have an address that's in Fulton County when you're released?
Yes, sir.
So you know where the office is, right down the street? All right, so you gotta be within 2 days of your release, whether it's a mistaken release or not. When you get out, just make sure you go to probation within 2 days after you get out, okay?
Yes, sir.
All right, ma'am, did you have a question?
I have a question. So my son is sitting in jail for about almost 30 days each time. Was he not get, because this is just an address change situation, not like, again, not him robbing anybody or committing a new crime, which you see those people every day, or people who don't comply with probation at all. Does he get any kind of grace here?
He does. The revocation wasn't, if this is someone who was robbing someone else, the revocation would be 5 years, not 90 days. So
does he not get any credit at all for any of the days he served so far to be reduced from the PDC sentence? He went from 60 days, now 30 additional days.
right, but one of the recommendations was 6 months, and that struck me as a not unreasonable recommendation. But to your point, Mr. Henderson has already been banking some time, and it's been difficult time because when he's at the local jail, it's particularly dangerous. And so when I'm thinking about the number I ultimately pronounce, I think about the different recommendations, and maybe I would have done 6 months, but there's already been this time, and you know, that Mr. Henderson won't go to PDC tomorrow morning. He'll be at Rice Street for a few more days, and those don't go towards the 90, which is why I didn't say 180, because then it would have been more like 210 days, and that's not what I think is appropriate. So I hear you, and I feel like this outcome is proportionate to what we're working through, the stakes that Mr. Henderson has in this. And that's why I started with what I started, is that if someone were just watching this, like, wait a minute, you're revoking this guy and all he ever did was he didn't connect with his officer. But we all need to remember the very, very thin ice that Mr. Henderson was on to begin with, the 25 years to serve. But because of good advocacy and reasonable prosecutors, it resulted in what I think is still the right outcome, where it was a probated sentence to a much lower offense that probably better fits the facts and circumstances of what happened, as you pointed out, many years ago when he was a kid. And so he ought not to bear the burden of that forever. I'm hoping that this stint at the PDC is it. And when I see Mr. Henderson again, it's because he comes into my business or I go into his business and he is successful at whatever he's doing. He's graduated from school or he's a junior in college, and you tell me how well he's doing. That would be the right outcome. We got to clear this up first, and hopefully that'll be a focusing device for you to make sure you are plugging in all the ways you need to with probation going forward. Okay? Thank you.
Thank you. You got this.
Thank you, officer, for being here. Appreciate the time.
May I be excused?
Yes, sir. Mr. Rhodes, we're going to try, did we?
He's not here yet.
He's not here yet. Okay. Okay, I'm just going to figure out what we're going to do next. Okay, so Mr. Willingham is not here yet, is what you're being told? Yes?
Yeah.
Okay. Once he's here, we'll bring him up and we'll take care of it. I have to step off while they take Malik Henderson down. He needs to go straight down. What are we doing next when I come back?
Either Hewley or Wilson, both of those are ready to go.
Okay, are those in custody or bond? Okay, Any other updates? I'm sorry, we are waiting on a prosecutor to show up. Maybe we could check on Mr. Peoples. Yeah. He is, as in, like, he just texted you saying I'm on my way, or?
I got an email that they were gonna come after the probation revocation.
Okay, like he was waiting for that to end.
Yes.
Okay, well, it's over. Maybe he's on his way. Appreciate your patience. Mr. Laremba, how are you, sir?
Doing great, Judge. My client is Antoine Owens. He's on the trial calendar. My announcement is ready to be reached. I have a special set trial start February 23rd, and Judge Adams in DeKalb.
Okay.
And we're going.
Okay.
It's not gonna work out.
I hear you, and it's specially set. Ms. Cabrera helped me understand, and really Ms. Rios did as well, that because it doesn't look like there are going to be any severances here, these three men will be tried together, and that's going to take a little more than a week. And my calendar is only 1 week long, so I'm gonna put this on kind of reserve backup. But if you can't be here, that's not a reason to sever. And so it's likely we couldn't do this because of your conflict. And we'll probably just need to specially set it because we've got 3 lawyers all busy and handle it that way.
When you special set it, Judge, what trial calendar would that be?
I'll let you know. I'll check your leaves and all that, but it would not be right away.
Okay.
Okay?
All right, thank you, Judge.
All right, good luck with Judge Adams if that ends up going forward.
It's going.
Do you need to speak with Mr. Owens?
I was gonna, he said he's not up yet, so I was gonna step out with people and to the back.
Are you gonna bring him up? Okay, great. Well, then, once you've spoken with him, you are free to go. If he wants to hear from me, to explain what's going on, I'm happy to own that. So when you talk with him, if he's like, I need to talk to the judge, that's fine. I'm happy to converse briefly with Mr. Owens to explain all the moving parts.
Great, thank you.
You bet. And now I'm gonna, nope. Okay. Excellent. I see him. Thanks for being here. Appreciate it. All hands on deck today.
Can he ask you, that would be put it for me for revocation to recommend that too.
Okay. All right. I was trying to knock out ones where we had large groups here. We've got Ms. Singleton here. So as soon as we can get Willingham, that's going to cut in line in front of everything else. But in the meantime, let's take some pleas. Do you want us to text you when he's here, or what works for you? Or you just want to lay on me what's going on? Oh. Okay, sounds good. That'll be our sign. Okay, when you walk in, we'll know. Okay, thanks. Ms. Rios, do you need to speak with Mr. Palmer anymore?
No.
He can go downstairs? Okay, yes. We were gonna do a plea, but in a minute, or you guys are able to get Henderson down while we do the plea? That's the only pleas lined up right now are inmate pleas. You can't do that? Okay, so I should just see what else we can move while you're taking someone down. Okay, go. Oh, come on, Simpson. Okay. Yeah. So we can do flag when we get a chance. Miss Scott, that diversion is moving along. How about Mr. Lewis? Jamal Lewis, that's you today. Is that some?
Judge, I am waiting for an answer from the prosecutor.
Okay.
Should be able to announce shortly.
Okay,
Thank you, Judge.
got it.
I'm just not charging you, you're reporting me about the, that's my whole.
Ms. Wood, we will do one of those custodial pleas. One, Deputy Gordon had to take some people down, and so we can't do any custody things until he's back. If you have any bond, anything.
I don't have anything.
Okay.
For my clients, I'm on. Judge, are you trolling us?
They're tasty.
Thank you.
It seemed like the kind of thing Rios would eat.
And there's another two.
Mr. Pennington, are you going to play Mr. Peoples?
Yes.
Because we have a very patient defense attorney, Ms. Sherry Lassiter, seated behind you right there, just waved, who is anxious to talk about the Teresa Smart case. If you guys want to go in the jury room, you're welcome to go in there. You can go out in the hallway, whatever your preference is. Ms. Smith,
Yes, Your Honor.
you're juggling a lot. Have you and Ms. Rios talked about position 26?
Mr. Scott?
It is.
Yes, you just talked.
That's what you were just talking about. Okay,
Gonna go back.
great. He's out. Yeah, okay, good.
That's a nice statement you're saying when you say it. You never refuse it. We'll get the same police reports next.
No, we were waiting for you to get out of there so we could get him downstairs. No, no, you needed to do what you needed to do. I was just wondering why, like, Gordon, why can't you, like, cause the Simpsons doing her thing.
I just want to do referral. For the one that Officer Adams said he did.
What's the, to PDC?
Yeah.
Let me get that first when you say it.
So Judge Emerson's trial is with the jury now. Yeah, there was not much of a defense. It was all caught on video.
Cause you stacking, yeah. No, you said the meeting. Yeah, you said the meeting. I mean, they moved the court to say that now. And then what they do is they take it, you won't even see it on Odyssey. You can-
It's also a position what we add-ons. Yes, sir. Plenty of Muslim.
Yeah,
It's gonna need a revocation.
okay. Thank you. Morning, Mr. Miller.
Good morning, y'all. How you doing today?
All right, yourself?
I'm doing good.
Good.
Thank you.
I do a person do my PTI. I don't wish to be your hedge. I have.
I think we should also use that as check it. And this thing is up to almost like to make it.
You should really know the show for CPI. Is just the charge.
What's the plan?
So we do have a plan, Your Honor. I spoke with Mr. Lester, and so she indicated that she has leave the week of the 23rd. I know Ms. A.A. Williams has leave next week. So my understanding is there's not a formal offer in case, or there hasn't been, or they've been going back and forth about offers.
There hasn't been a formal offer made as of yet.
Okay.
So what we've talked about is a very unique set of circumstances, much like Ms. Cherry Laster is going to submit to the state mitigation package by the end of next week, right? Before she goes on leave. And then the state.
You're going on leave or before Ms. Williams goes on leave?
No, Ms. Williams is on leave next week.
Okay,
And then she goes on leave the following week.
okay.
Week of the 23rd.
Oh, so you're not available for the trial calendar anyway? Okay,
But the hope is that once I submit my package, by the time she gets back, she'll have a chance to review it. By the time
Sure.
I get back, I have off.
Yeah,
got
so
it. So while Ms. Williams is at the beach, you'll put together mitigation. While you're at the beach, she'll read mitigation. Everyone will come back rested and cooperative.
Yeah, that's the hope.
Okay,
And then to then have an offer, be able to have discussions with it, because I think it's just the unique nature of the case, it makes sense to really kind of try to understand what's going on here before we get to like the hopefully the best resolution we can.
That's correct, yeah.
okay. Is it realistic to think you can complete the mitigation packet by the end of next week?
I am meeting with my client again tomorrow, and that is my hope. It may be some documents that I'm not sure if I can get the hold of by the end of next week. But at least I can have something to say, we should maybe wait on a document or something like that to get started.
Okay.
It can't be complete, but at least it'll be a start.
And it's your sense that if there's a delay, it would be in obtaining documents that already exist as opposed to I have to have my client evaluated and that takes 6 months to write up. It's all things that exist. It's just getting your hands on them. Okay. And you will let, if there are things you don't have, you'll let Ms. Williams know. And I also expect this, I don't have the documents yet, but they'll say X or Y or Z. Okay. And then Ms. Williams can process that. And then the two of you can reconnect about, is there a non-trial resolution for the case? Okay. So if we moved this to an upcoming trial calendar, just not this one, that would allow for time to do all that.
March trial calendar?
It may be. I have to talk to my boss about whether we can put things on the March trial calendar still. It's filling up, but it wouldn't be before then because this is the one you're on right now is the one before it. So I just don't want this to be hanging out there. Ms. Smart can't move in any direction she wants to with these are serious charges until they're resolved. That's complicated. And there may be bond conditions that are making her life complicated and those can't change until the case is resolved. So I'm anxious to make sure we're moving it along. Okay. 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 All right. Pardon me? Okay. It's going to be on March. It'll be on the March calendar, which I think is called on the 12th of March. And then it's the 2 weeks following it are the actual trial weeks. But March 12th is when, so 1 month from today, we'd be back here. There's no need to wait to that magic day. If you and Ms. Williams sort something out, because Ms. Smart's on bond, it's real easy to say, great, come in this afternoon and we'll do whatever we need to do. But March 12th would be the time where definitely by then we're saying, yes, it's going to resolve or no, it's not. Okay? Ms. Smart, do you have any questions? She's not here. Okay, well, you're hearing it. That's the important part. You can let her know. Mr. Pennington, thank you for filling in for Ms. Williams. All right? Yes, ma'am. And you'll let your client know? Okay.
Your Honor, is there anything else?
I don't think so. I think that was the one.
Okay, thank you.
I just wasn't sure if you had published it yet, so I didn't want to dust settled from today. Good. What gets moved over?
Love that. She came down. It's chasing someone with a crook. Like you did the shit. But she says that was being a fun trial. Yeah. I think the police were in this even having been that's not what was charged. So yeah, I would be able. I'm stressed. So y'all doing that next? What else you got? And the probation revocation. Oh, okay. Yeah, she's out there talking. Wait, the is he on bond? Yeah. Oh, you can. Oh, when she gets back, you can do it.
Yeah, anything on bond we could do right now.
When Ms. Smith comes back, we can do Mr. Tremaine's, what's the last name? Scott. Final plea hearing.
Great. It's on for final plea?
No, so we reserved his.
Oh, his final plea rights?
Yeah.
Okay. So he can come back on Monday, the 23rd.
Are you feeling better?
I am. I don't necessarily sound better, but I'm feeling better. Oh, well, great. Look at that. I sound great. I'm not 100%, but the cold germs are being defeated.
Oh.
Where did Ms. Smith go?
She's talking to the tall attorney man, what's his name? Oh,
Pennington?
yes, or Mr. Spurling.
Oh, defense attorney.
Yes.
Okay, Sperling. The tall attorney.
For sure. Oh, for sure. Yes. I think we're ready to go on the final plea hearing.
Okay. I'm gonna let Ms. Smith just take a breath as she comes back in. Ms. Smith, what we're gonna do when you're ready is have the final plea conversation with Tremaine Scott, which is position 26. And then we still can't do custody pleas because Deputy Gordon's not back. And I guess we don't have any bond pleas because I think Mr. Scott was the last one. Oh, except what's happening with you were talking with Mr. Sperling.
We're trying to get that resolved now.
Okay. Oh, yeah, he said you needed to get back to him on something. And maybe you just did that, or is Mr. Miller dealing with him? Excellent. Okay. Mr. Scott, if you'll come on up to the podium, please. All right, we're going to get on the record in your case. It's 25 SC 004557. You are charged with aggravated assault, which is an offense that carries up to 20 years in custody. Ms. Smith, if Mr. Scott wanted to resolve his case today, what would... Welcome back. We're ready for pleas once...
Everyone's up, but I'm gonna sit here.
Okay, as long as you don't have to go away.
No.
All right. Sorry, Mr. Scott, I get these interruptions. Ms. Smith, what is the state's offer in Mr. Scott's case?
Yes, Your Honor, this morning the state provided an updated offer of 5 years to serve 4 months balance probated.
And 4 months seems pretty specific. Has he already done 4 months, or it would be prospectively he would go into custody?
Respectively, you've done after 31 days in this case.
Okay, so he'd go back into custody.
Yes, Your Honor.
All right, balance on probation, any particularly challenging conditions?
Just DA management course and then no contact with victim and stay away from this.
Okay, got it. So, Mr. Scott, if you were to enter a plea today, the state would recommend that you go back into custody. It sounds like it would be at most 3 months-ish, and then have a little less than 5 years probation. That doesn't mean that's what Ms. Smith has to recommend. She could recommend something different. If you entered a plea today and you disagreed with your sentence, you didn't like what I imposed, and it was more than what Ms. Rios asked for, you could withdraw that plea. After today, you can still plead. You could decide, I don't want to go to trial. It's not going to go well for me. You just don't get to withdraw your plea if you are unhappy with the sentence that you get. Does that make sense?
Yes, Your Honor.
Do you feel like you understand what the state is recommending?
Yes, Your Honor.
Okay. Do you want to go forward with either a negotiated or a non-negotiated plea today?
No, Your Honor.
Okay. You'd rather go to trial?
Yes.
All right. We will move your case to the trial calendar, which is a week from Monday. And I am adding you, this is number 26, to the list. Sounds like this would be a case we could certainly try within that 1 week. So you need to stay in touch with Ms. Rios, but it's likely that you'll need to be here on Monday, the 23rd at 9 a.m., ready to pick a jury and go forward with that. Again, on that day, you could enter a plea. The only difference is, I don't know what the state's going to recommend. They could recommend more, they could recommend less. You just won't get to withdraw your plea if you're unhappy with the sentence. Understand that?
Yes, Your Honor.
Any questions about anything we just discussed?
No, Your Honor.
Ms. Rios, any discovery concerns about this case?
I don't believe so.
Okay, then I will see likely both of you on Monday, the 23rd. And if you don't have anything else, you can go when Ms. Rios says she don't need to talk to you anymore. All right?
No problem.
Yeah. Yes. It has the flat. It's not the circle. Yes.
Judge, don't get approached for a brief moment.
Is there a reason we can't speak openly about it?
You can.
Okay, let me find the case.
This is Jamal Lewis.
Right, it is in here somewhere, number 22. Okay, what's happening?
So, Mr. Lewis, PTI. He was denied for PTI based on the fact that he was charged with aggravated assault. Now, this is a case that involves my client and other young men. They were basically playing with guns in the woods. And one of the young men shot a gun, but hit one of their friends. They were all friends. My client was never arrested for ag assault by law enforcement. She wasn't the one that even shot the gun. So at some point, he was arrested for misdemeanor. Eventually, he got indicted. The state acknowledges that he frankly should have never gotten indicted for ag assault because he's not the one that shot the gun to begin with.
Okay.
So the state sent the case to PTI. PTI declined, he was not accepted for PTI.
Yep.
Under the premise that it's an aggravated assault.
Sure.
We just had a conversation out in the hallway with the PTI supervisor or coordinator where the state very kindly explained this is not an ag assault, should have never been an ag assault. And it's my understanding they're going to accept my client into PTI.
Mr. Miller, who were you speaking with out there?
Yes, Your Honor. I spoke with Deontay Pollard, who's the director of our adult diversion program.
Okay.
We did explain the situation to him, the charges and state's intention of not processing the felony counts and sending it over for adult diversion. All of that was sent in an email February 3rd. I think nothing goes better than verbal confirmation and explanation. And so Mr. Pollard had agreed that he is a great candidate for PTI. And so he did indicate that he will be sending over an email shortly with the new terms and conditions of the adult diversion program.
Okay.
He did add a caveat, which is different from the normal terms and conditions of our adult diversion program. It's my understanding that this defendant wishes to join the military. And so we just added that he provide proof that he signs up for the Marine Corps given some wiggle room in the event that he's not accepted for whatever reason. We at least want him to attempt to sign up for it.
Got it. Is Mr. Lewis in here right now?
He's back there, Judge, and we had a letter, a 2-page letter.
There he is. Okay.
From the Marine Corps outlining that he is applied, he's pursuing the Marines. And when Ross Gordon, who works for me, spoke with them, he was told that the misdemeanor charges for which he was offered a plea would be very problematic for him. So that's.
Got it. Which is why diversion will preserve that opportunity to serve the country. Got it. So it sounds like things are working out well for Mr. Lewis and in the right way. And then Ms. Smith, you will, once the email comes across, prepare that standard, or will it be Mr. Miller? One of you will prepare that standard order that I get that says, here are the conditions. You've got you usually get a year, but you can be done as quick as 6 months if you do all the things. And there'll be that atypical condition of you've got to provide proof of attempt to enroll in the military or whatever language you put in there. Okay. That seems like a real reasonable outcome. Mr. Lewis, do you understand what was just discussed? Did Mr. Sperling talk to you about what the requirements are? It may have been Mr. Gordon talked to you about the requirements of pretrial diversion. Can you speak louder, please? Okay. Well, when you heard them, was your reaction, oh my gosh, I could never do that? Or was it like, hey, I can take care of that? Good. I think you can as well. It sounds like that's how your case is going to work out. Mr. Sperling, I appreciate your persistence on this one. What deadline should I put on my calendar as to when I can get that PTD order? End of week? Is that too soon? I know you don't control the flow out of that group.
In terms of the order?
Yeah, because usually Ms. Smith says, Judge, here's the proposed order, and then I look at it and we're good to go.
I would say a week, just to be on the safe side, but if we receive it today, then I would say by the close of business tomorrow.
Okay, I'll just start bugging people next Wednesday if I don't have it. Okay? That means, Mr. Lewis, you do not need to show up for the trial calendar. And Mr. Sperling, you've taken care of this one.
Judge, always a pleasure. That completes my business and every excuse.
Yes, sir. Thank you.
Take care, Judge.
Thank you.
I appreciate it.
All right.
Ms. Cabrera, should we talk about that bond situation? Is that it? Okay. And Ms. Singleton, you're back. Does that mean he's here?
They're pulling into the courts.
Excellent. Oh, Mr. Roberts, right. We finally can do jail pleas now. We had been stuck. All right.
And Your Honor, Mr. Pollard did submit, he just sent over that acceptance for PTI for Mr. Lewis.
Fantastic. That was fast. We got to have you run these next time. Williams.
You don't have one?
No, I have one. Absolutely.
What color? Oh, see, I'm looking at one of the cool kids.
So, Ms. Cabrera, the curfew is 7 p.m. to 7 a.m. Live with grandmother, Ms. Jones, at an address in Lithonia. No contact with the other two defendants, which should be pretty easy since they're in custody. No request to change any of that. It's just turn it into a county-funded ankle monitor.
That's that. That was the primary stuff on the last side. Yes. Okay, then the curfew, that's what he said, he bring up, the curfew was modified. The curfew was modified for him to, be home by 8:45 and allow him to leave at, 5 in the morning so that he could, work.
Yes, that happened in August. There it is. Thank you. Because he is in school and is working with Steel LLC. Still true?
Yes. Stand up with justice.
Oh, I don't mind. I just need to be able to hear you. Yes, you're still working? Okay, but these hours, the 8:45, you gotta be home and you can leave at 5 in the morning. That will still support work and school?
Yeah, it's good for school, but I leave school at 7:45.
Okay, where are you going to school?
11:10.
Okay. Do you need the 5 AM or can that be later?
If I get a job, it's still the, yeah, but,
Okay, I don't want to have to keep shifting it on you. If there's a likelihood that you get a job and that job would be early in the morning, we should leave it like this. Okay, so we'll leave the curfew as it was modified recently. That's the 8:45 PM. You're home. You can't leave until 5 AM. Hold on a second. Staying at your grandmother's still works? Okay, that's where we would find you each night? Okay, all right. I will take care of that. So the only thing I'm changing is that it's a county-funded ankle monitor. Are you using Second Chance? Is that where you got your device? Okay, that'll make it much easier because they are the vendor for county-funded. I don't know that they're gonna make you switch out devices, but it's possible that they contact you to say, we gotta give you one that says Fulton County on it or something like that. But they may just say, you've got the same device, but then the bill comes to the county rather than to you. Anything else, Ms. Cabrera, on Mr. Williams? Okay. All right. I will take care of that. Can we do a plea?
Please.
All right. I think Deputy Gordon's back. He just went to check on things. So, yes.
Mr. Roberts, you want to do a different one first?
We're going to do one of Ms. Woods and then we'll do Mr. Roberts. Hey, Mr. Chamberlain, you good? I'm all right. What's up?
Yes. Thank you.
Okay.
So that's the issue.
So will Great House fix it or what do we need to do?
No. He did an updated list.
And she wasn't on it.
She was on it, but the person who rejected the stuff didn't have the.
Oh, it didn't have the updated list. Okay, that fit, because I saw that it said you don't have authority, but she files stuff all the time. Why wouldn't, I guess not.
Person.
Yeah.
Found 6, whoever accepted the first 6.
Had the good list.
Probably had a good list.
Okay.
The person that did the other 3, I found out who rejected each document. The same person rejected.
Okay, your detective work.
I did,
Yeah.
because I want to make sure
Yeah.
it's okay.
Yeah. Right. It didn't make sense that some will go through and others wouldn't, but, okay. So has the clerks, they fixed it?
Well, she was the Miss Blow is the person in the clerk's office. I called her and basically and I told her who rejected it. She
Got
was
it.
like, she probably didn't have the new list. But I
Okay.
made sure she.
Ms. Lowe will fix them. Okay, excellent. Thank you. That makes so much more sense.
Okay.
Did anyone respond to your knock?
No, and I just sent a text message to Deputy Gordon as well. It looks like Judge Lettridge has court as well today.
She does a bunch of revocations.
So they're doing a great job.
They are. I'm impressed. I just
All
need
of
to
us.
keep Gordon closer. Are we going to do Mr. Flag or who are you having?
If we could do
We can-
Jerry Hughley, which
Mr.
is-
Hughley. Okay.
He has family here.
Okay, we'll do that. And then we'll do Mr. Roberts. Hughley, then Roberts. Such a powerful knock. I'm sure they're hearing it way back then. Your voices. Where'd you go, man?
I got Willingham.
Of all days. Okay, we are gonna do Hughley. Hughley, is that all right? Or we have to do Willingham because he's right here.
That's fine. Is that your case?
All right, bring him out. It's a bond hearing.
Oh, okay.
You can stay right where you are. And you're welcome to move, but you don't need to. You good? Okay. Okay, let's get on the record in State versus Willingham. This is 26 SC 000020, the 20th charging document of the year. Mr. Rhodes is here with Mr. Willingham, and we have Ms. Smith for the state. Mr. Willingham, it's still morning. Good morning. We are able to go forward now, and it was only a couple days. You had to wait from when I had you here last with the bond hearing. Ms. Smith, the prosecutors had a chance to be prepared for it and make contact with the alleged victim, et cetera. So I'm going to hear from your lawyer about what bond should look like for you. I'll hear from Ms. Smith. We also have Ms. Singleton here, and she's going to share with me a little bit about you, how you've been doing, and if there is a juvenile history that you've got. And then I'll let you know what the plan is. Mr. Rhodes.
Yes, Judge. Kanye, as you've been informed, is 16 years old. He'll turn 17 in the next few weeks, at which point, if he were to remain in custody, he would be transferred to Rice Street. This case, as a procedural history, it was dismissed at prelims and then re-indicted, and now we are in front of you now.
Was it dismissed on the basis of lack of evidence or on the basis of lack of officers showing up?
The officer did show up and testify.
Oh, okay.
So it was dismissed somewhat summarily after that. But
Oh, not establishing venue.
Yes.
Okay, so not that there wasn't a crime, but that it maybe didn't happen in Fulton County.
Correct.
Okay, interesting.
Or at least it wasn't submitted as evidence that it had occurred.
Got it. Okay.
Yes, Kanye's been in custody continuously since December 5th of last year. Even after that dismissal at prelims, he was still remaining in custody. The judge did not sign a release order that was necessary for him to be released. And then within the week, Yes, it was re-indicted and we're still here.
Okay.
But yes, that's a procedural history of this case. Kanye, to speak of him and Bond. Well, also still in terms of the facts of this case, I don't believe that it was ever alleged that Kanye, this is an armed robbery case, that Kanye was ever in possession of a firearm. There was a co-defendant who indeed, per the police report, was, or at least brandished one in the course of this incident. Kanye was just allegedly next to that co-defendant. Kanye still, this incident date, I believe, was in October. You will hear, I'm sure, from Ms. Singleton that he does have several other juvenile cases open. Those were from, I believe the incident dates of that were in April of last year. Since then, Judge, he has been enrolled in what's called the Youth Build program. He began that in September. Youth Build, and I'll have he does have a lot of representatives here today, and they were here on Tuesday as well. But I will have one of the representatives speak to the details of what Youth Build is and what Connie has been doing with Youth Build. But in general, it is a mentorship and career building program, helping to make sure that young kids are able to plant themselves and become proper citizens in the world. Kanye has been working on a construction license as well as getting his GED with that program. He has completed several practice tests for his GED and has aced them. So he is doing well on that front. He does, again, have a lot of family support. His mom is here. I believe his dad was here last Tuesday, wasn't able to make it here today. His grandmother is here and several relatives as well. Should he be released, he will be very, very, very well supervised. I say all that to say that he does have an active community here to ensure his development, his proper development, and to ensure his continued success. I was speaking with his grandmother earlier. She was saying that Kanye has gone to church with him and does regularly go to church with her and contribute to her church activities, including feeding the disenfranchised and homeless. We would ask for bond to be set for Kanye. I will again also say that during his custody at the Metro YDC, he has exceeded there as well. There have been no negative incidents that have occurred since he's been there, and he has been fully excelling in his classes. He's been receiving certificates and doing a lot of extracurricular activities there as well. So he is truly a kid who is on the up and up. These mistakes and these incidences have occurred for the most part, yes, prior to this incident date for this case that we're in front of you now, and before his enrollment in Youth Build. And if I may, Judge, could I have someone from Youth Build speak about the program?
Sure. Before you do that, but I'd like to hear from someone there. Tell me where Mr. Willingham had been in school and why he then wasn't in school, because you've talked about Youth Build. He's 16, so there should have been a high school at some point he was going to. What was that high school and how did that end up?
Forgive me, Judge. I need to refresh myself on that.
All right. You're also welcome to ask him since he's standing right there.
Benjamin Mays. Yeah, he was at Benjamin E. Mays High School.
Okay. And were you a student there until this incident, or did you stop being a student there before this situation?
Stop being before.
Why did you stop being a student at Benjamin E. Mays?
Because when I got released, when I was on house arrest, I got kicked out. I had to go to alternative school, but I didn't want to go to alternative school. So my cousin told me about Youth Build.
Okay.
Enrolled in Youth Build.
Okay. And when did you start Youth Build?
Can't remember.
From my notes, it was in September of last year.
Okay. All right, so something happened, not this case, that caused you to get removed from Benjamin E. Mays. And then the plan was maybe go to alternative school. You said, I'll do youth build instead.
Yes, sir.
Okay, thank you. So yes, if there's someone here from Youth Build, happy to hear from him or her.
Yes, Ms. Hall.
You can go up to the podium. We just need you near a microphone so the court reporter can hear you. So if you know Mr. Willingham, you can just squeeze on in there.
Okay, yeah. Very familiar with Mr. Willingham. I actually refer to him as my son.
Can you give us your name?
Yes, I'm Amber Hall. I'm known as Miss AJ in the program. My colleague, Mr. Shane Little, is here with me. He is our construction training manager. Kanye, I will say, does not always hang around the best crowd. However, he has a heart of gold. Just wrong place, wrong time with the wrong people. And we were working diligently on just separating him away. I was previewed to the juvenile case. And then actually the young man who was—
You say the juvenile case, meaning the thing we're talking about or whatever got him kicked out of? Okay, which was what kind of allegation?
It was a juvenile case, so I wasn't privileged.
Oh, okay. You just knew he had run into some trouble and he came to you.
Correct.
Okay.
And so actually the co-defendant in that case, who is older than Kanye, referred him to the program.
All right.
And so he then said, hey, Kanye would be a better fit. So he said, you guys keep Kanye in the program and I'll just go over to the At Promise Center. Since late, I believe Kanye was accepted into the program late September 26th. And since then, he has accomplished over 120 community service hours.
What does that mean? By which I mean, is he serving meals? Is he cleaning a park? What is community service?
So we've done cleanup around the neighborhoods. We've done feeding the hungry. Organizing materials throughout the program. They order a lot of construction materials, so he gets community service hours through that. And just being active in the community in a positive way. He's actually went down to the daycare center inside of the building that we're at and volunteered to read books to some of the children, all of that. I told the last judge that I was in front of, this kid that is on paperwork is not the kid that is enrolled in our program. He's a leader. He doesn't say much, but when he walks in the room, he gets everybody attention and he can literally get everybody on one accord.
All right. And you've worked with Mr. Willingham for how long?
Since he did 2 weeks of orientation, which we call mental toughness, prior to being accepted into the program. So since early September, and we work together day to day. I have text messages. He was on an ankle monitor. He would state when he was on his way to programming and when he was on his way home from programming. I highly suggest if he does bond out that an ankle monitor is the route that we need to go back into. I've just seen significant change. I'm his case manager. Case manager title was just a little too defecty for me, so I went with youth advocate. And ever since I've been able to work hand in hand with Kanye, we've made tremendous progress. He's earned his logistics certification. He only needs a score of 145 on his practice test to be eligible to take the actual test. Kanye has scored on average in every subject of 160.
Is he eligible to return to Youth Build even with these charges if he gets a bond?
Yes, sir. I specialize in court-involved youth. I was a Youth Build graduate myself, class of 2010. So I've been an at-risk youth before. And I believe that I've been blessed with the purpose and gift to help young people recognize their potential and turn their life around.
Youth Build has been here in Atlanta since 2010?
Yes, so it's actually GAPTA Youth Build, and GAPTA is abbreviated for Georgia Building Trades Academy. And then once Mr. Shane certifies him in OSHA 30, CPR, first aid, multi-craft core curriculum. He gets direct entry into any apprenticeship trade. Being that he's 17, he's eligible to go right into sheet metal.
Almost 17.
Almost 17, yes.
So what about high school, GED? How does that work?
So being that he's already exceeded the score of 145 on the GED practice test, his mom has granted permission to the state and Atlanta public school systems to go ahead and take the actual test. There's no doubt in my mind that Kanye will not have his GED before March the 20th, which is our graduation date.
Is obtaining a GED a requirement to graduate from your program?
No, he's already met the requirement, and that was just to get a basics logistics certification.
Okay, got it. How many youths participate in your program?
We're funded by the Department of Labor, and we serve 66 students over the course of 3 years. So even after Kanye graduates in March, I would still follow him for a year. And so we would need to check in minimum once a week.
What is your Youth Build's approach to providing notice to others who are trying to supervise if something doesn't go well? And I'll be clearer. If Mr. Willingham is on bond, Ms. Singleton will be supervising him at least for 7 days, maybe longer. I never remember how it works once someone turns 17, but there'll be supervision.
Okay.
Whether it's through adult pretrial supervision or through the good work that Ms. Singleton does. And it's important to me, and I suspect those who are providing the court supervision, that if there is a program that the young man is participating in, if he stops showing up, there's notification like, hey, I just need to let you know, we have not seen Mr. Willingham for a week. Or at least if you get that call, hey, it's Ms. Singleton, I'm checking in. I haven't seen Mr. Willingham, we're concerned, as opposed to, I can't disclose that information.
Absolutely not. So with his juvenile monitor, we actually had a group chat text with my director, myself, his mother, and Kanye. So at any point in time, if he's supposed to be reporting, Kanye knows, and this is more so coming from my mother term, I'm not supporting you if you're not doing the right thing. So if Kanye was a complete menace, which I do encounter those as well, I wouldn't have even shown up in court. I wouldn't have invited his youth advisor with WorkSource Atlanta, and I wouldn't even have gone out my way to ask Mr. Shane to be here.
Got it. Okay. Well, I appreciate that. It is definitely a sign of your belief in and confidence in Mr. Willingham that you're both here, and you've been sitting here since 9 a.m, and you have other places you
He traveled all the way from Conyers, Georgia.
Okay, that's a big commitment. Mr. Willingham owes you a lot of hammers and nails or whatever happens on the construction side. Okay, anything else, Mr. Rhodes?
Yes, Judge. I would, of course, just ask that bond be set for Mr. Willingham at a reasonable amount, not to exceed, I believe, well, 15,000 on an armed robbery might be reasonable. And I say that again because
I need you to tell me reasonable in terms of affordable, because I understand armed robbery is serious. I see armed robbery bonds that are $100,000. I see armed robbery bonds that are $10,000. But I need to know what the family can afford, because that's what makes it reasonable. It's automatically an unreasonable bond if it's out of financial reach of the family. So I rely on you to have consulted with the family to say, if we stretch, we could make this. And it may be that you say, look, it's $1,000. And I may say, I can't do that. But it may be that you say it's 15,000 or 20,000. I have zero visibility into family finances.
I understand. Well, yes, I have consulted with his mother about affordability. She'll do, as she says, whatever it takes. However, I am still, a public defender. I represent indigent clients, as you're aware. So although I wasn't given a number, I'm hoping for a lower end of the spectrum in terms of bond for an armed robbery. I just threw out 15,000 because that is typically a lower end bond for armed robbery, but court's inclined to go even lower, again, considering my client's indigent status. We would, of course, be appreciative of that. We would also ask for additional conditions that I'm sure Ms. Singleton will give as well, but we would request an ankle monitor. If that would help ensure his placement and location, and a curfew as well. As I mentioned before, he is well supervised. He would be living with his mother. And he will be active, completely active with Youth Build and his mentors there as well. So has a lot of hands over him, a lot of support. You know, an ankle monitor and curfew might not be necessary for that, but we still would recommend it so that there is an assurance that he will be where he's supposed to be at any given time.
Ms. Hall, as I think about curfew, if I'm thinking about conditions, if I set a bond, what are the reasonable hours that Mr. Willingham would need to be away from home so that he is showing up on time and for as long as he needs to be there, or could be there? It could be that programming ends at 2, but people who want to do more can learn how to use a power tool and they stay late. What are good boundaries for a curfew for full participation?
So we normally operate Monday through Thursdays, some Fridays for community service projects and mentorship workshops. I would like to add that Kanye also has the opportunity to go on work experience, which he has to be drug-free for 8 weeks. And then he also has an additional opportunity to work throughout the city, throughout the summer for the city of Atlanta. So I would think reasonably 6 a.m. in the morning to maybe 6 p.m. at night, he should be home. Mr. Shane doesn't stay any later than 4 p.m.
So he's got to get all the way to Conyers.
Correct.
Right. Okay. All right. And there's never weekend work or this or that.
There are some additional construction shops on Saturdays once a month. However,
if he did not do those, would he be in any way disadvantaged in the program?
not at all. That's not even with Mr. Shane. That's
Okay.
just extra.
If I'm trying to create bright lines, it would be your curfew is Monday through Friday, 6 A to 7 P, well, it'd be the reverse, 7 P to 6 A, but you're at home on the weekends. Okay. All right. How do people get referred to and accepted into your program?
Acceptance completely depends on them. They have to show that they are worthy of the Gap to Youth Bill standing. To reach us, you can either go to gapto.org or I will leave my phone number.
Do you have a card or you're not a card person?
Every time I get cards, I'm like the only staff member that don't get to keep my cards.
Okay.
One officer cards are getting the electronic cards though, so.
Okay.
we'll give those out.
Something's heading my way though. I want to keep this program in mind. It fills a big gap that we have for the right. Is it both genders or just young men?
No, both genders.
Okay, it fills the gap for young people. Okay, thank you so much.
As of this year, we're going after a little bit bigger grant. So instead of being able to serve 66, I'll be able to serve 86 youth.
Okay.
I do a really good job, Judge.
If you don't say so yourself. Okay, little self-promotion. Amber Hall, AJ. All right. What else?
That's all I have.
Thank you. That's very much. I appreciate both of you being here. And I'm going to hear now from Ms. Smith about the state's perspective.
Yes, Your Honor, thank you. In this case, the state will be asking for no bond for this defendant for the 2 reasons. The first reason is the risk of reoffending. We did get a chance to look at the defendant's GCIC. There's an entering auto arrest from 2024 that I believe he was adjudicated on. And after that, in 2025, there's another entering auto arrest. I'm not sure if that's been adjudicated or not. I did speak with Ms. Singleton.
So two different arrests.
Yes, Your Honor.
Okay.
One from 2024 and one from 2025. Also in 2025, Your Honor, there was a theft by receiving stolen property arrest. don't have a disposition or an adjudication on that case because it is a juvenile case. However, this does raise the concerns of the state that if the defendant is let out on bond, that he will reoffend in this case. I did hear that Ms. Hall stated that Mr. Willingham began the Youth Build organization in September of 2025, but the case we're here to talk about today happened in December 2025, around 3 months after he started this program. So I do believe that it is a good program, but the state does not believe that this would limit the risk of the defendant reoffending if he is released from bond. And because of the severity of the charges, Your Honor, starting with entering auto to theft by receiving stolen property and now to armed robbery, looking at the crimes or the allegations we have in front of us and not deciding today if he's innocent or guilty, but just looking at the charges we have in front of us, the state does believe that the charges or the decisions by the defendant has escalated over time and raises a higher risk for the defendant to, one, reoffend and be a danger to the community if he is let out on bond. These types of crimes of taking people's property, sometimes using weapons or breaking into people's vehicles, we do believe that the defendant would be a threat to the society if placed back in the community around other people's things or property that probably does not belong to him. And because of the risk of reoffending and also the state's belief that the defendant may be a danger to the community, the state is requesting that the defendant receives no bond in this case.
Do you know, I'm looking at it's the juvenile packet, so it looks a little bit different, but it looks like it's the affidavit from the officers who were involved both with responding to the armed robbery, which is actually October of 25. And then Mr. Willingham wasn't arrested until December of 25. He was driving in a car with an expired tag and they pulled the car over because of that. It was Mr. Willingham and he had a warrant for the armed robbery from October. But the description of the armed robbery is, as Mr. Rhodes alluded to, two people. It doesn't necessarily say who had a gun and who didn't, but it's two people. Anything about the co-defendant?
No, Your Honor, we don't have any information on the co-defendant.
Okay.
The state would like to add, though, that I did get a chance to speak with the victim in this case, who is opposed to bond for the defendant because of having to.
What he went through? Sure. Okay.
To clarify, was the victim opposed to bond for the unnamed co-defendant or Mr. Willingham?
The victim was opposed to bond for both. Yes.
At least according to the victim in this write-up, one had a gun in his waistband, then both rushed, and one of them pointed the firearm. They took the drone, and they ran away. So that's not inconsistent with what you're saying. It's just not Mr. Cruz saying, because he didn't know these people. Although they're clearly knowable because it was a Facebook marketplace. It doesn't sound like it's going to be hard to figure out who the other person was if the police leans into it. Okay, Ms. Singleton.
Yes, Your Honor.
Good morning.
Good morning. As to the defendant's juvenile history, he has a September of 24 entering auto, a April the 12th of 25 entering auto and loitering in plow, a May of 25 theft by receiving motor vehicle, a June of 25 theft by taking motor vehicle, and a second June of 25 theft by taking motor vehicle. The last three cases are pending adjudication, with the defendant having a court date in March for the cases to be resolved for the ending of those cases, Your Honor. And I did speak with juvenile court to confirm that. The defendant, my information concerning how the defendant's behavior has been in the facility his behavior has been okay. He's not extremely aggressive or completely out of situations, but his behavior has been okay. However, he has received several certificates while he's been there. He has an outstanding in math certificate, and he also has an outstanding English language arts, as well as, I believe, a certificate in the guitar program that they have in the facility as well. If released, he would be able to receive all the standard SB 440 bond conditions. After he turns 17, he would still be under my supervision. because we're so close, if the court does grant a bond to his 17th birthday, it takes around 3 to 5 days for the SB 440s to get out of the juvenile facility, which would put us probably close to his birthday. So I would still request that the court put that he receive the DJJ ankle monitor and convert to the county funded monitor upon his 17th birthday, just to cover the possibility of a gap if that were to occur. He would be eligible for wraparound services, but he would only receive those for a couple of days. And I would be able to supervise him with his participation continuing with the youth build program, as well if that's what the court would desire.
Got it.
No social media and no weapons, Your Honor.
Okay. Mr. Rhodes, as the movement, anything you want to add?
You've heard everything, Judge. You've heard a confirmation of his history. I would say that those incident dates are prior to his entry into youth build, except for this armed robbery. We would concede to that. But we do understand that, you know, he understands and his family understands that he was heading down a wrong path. And that's how he became self-motivated to enter this youth build program. As you heard from Ms. Hall, it is a self-motivation thing. You can't succeed and you can't really be enrolled if it's not something that you yourself want to do. So since entering that program, he has been doing extremely well, Judge. And he will continue to do extremely well. He has a lot of people who are invested in that. So again, yes, with that in mind, we would just ask for reasonable bond to be set.
Okay. Mr. Willingham, I am very, very impressed with Youth Build and what they offer and what they have offered you. I think it is a good showing that you have family support as well. What I struggle with is the fact that despite the support and the structure and the future that the Youth Build program affords you, in the midst of that program, you've been there probably over a month, this situation happened. And I'm not saying who did what to whom, but it says to me that the structure that mom provides and family provides wasn't enough to prevent, all in the same year, Inter Auto number 1, theft by receiving 2 stolen cars in the same month. Things slowed down a little bit. You got out of Benjamin E. Mays, you got into Youth Build, but even that didn't pull you out of the cycle of, I can't blame the people you're with, because I don't know if that's exactly what that young man and his parents would say, is that my kid's good, except when he's around Kanye Willingham, and then they do these crazy things. And that's not what this is about. But I need to be confident that the Rafael Cruzes of the world aren't going to get a gun pulled on them and their drone taken when someone says, hey, you have a drone to sell, let's meet at this place and we'll buy your drone. And I'm not confident that Youth Build is going to prevent you from doing that, because you had Youth Build on your side and you had Ms. Hall and Mr. Little on your side. So I don't believe that putting you back in that same environment is something that keeps, most of all, you out of trouble, because something like this, Mr. Cruz could have had a faster and bigger gun and you and your friend are dead or whatever. I mean, that's how dangerous this is. No one got hurt, and that's good. But this is the kind of thing that I see ending all too often. There's a young man dead on the ground, and that's never okay. And that's how risky your behavior has gotten. And there's nothing that says the curve is going in a different direction, except everything Ms. Hall said is, oh, this is all great, until I realized, wait a minute, this happened in the middle of your time at Youth Build, not before you got there. And so I can't look to them to say, hey, look, you're keeping them out of harm's way. It's not their job. They're there to give you opportunities and teach you and stretch you. But you gotta step up and not end up doing things like this. I don't need to give a sermon. We'll do that later on down the road. I just need you to understand, after having heard these amazing things from Youth Build, when I heard more about what last year was like for you and the fact that this happened after Youth Build, I can't set a bond. I don't think that putting you back where you were keeps people safe and keeps you safe. So you can roll your eyes and roll your head, but the facts are the loudest thing on the ground right now. And the facts are you were in Youth Build and this situation occurred. Now, Mr. Rhodes is a good advocate. He's going to get to the bottom of this, and it may be you're a bit player in what was a real dangerous situation. But until we suss that out, you're going to stay where you are. Mr. Rhodes knows that I will revisit this. As he gets discovery and learns more about the case, he may be able to get back here and say, Judge, you know what? It doesn't look like it, what's on paper. And here's why you need to get Mr. Willingham out while we sort the rest of this out. But the way things are right now, given your 3 open cases in juvenile court, this open case in adult court, I can't think of a bond that is going to reduce the risk, because those risk reducing factors were already in place. You were being lifted up by Youth Build and your mom was there for you. And even though you had 2 open stolen car cases and a theft by receiving case, this situation happened. So I'm going to deny bond at this time. I'm open to reconsidering if there's new information. That new information wouldn't be, no, Youth Build's even better than you think, because I am phenomenally impressed with Youth Build. It would be, there's something about this case that doesn't add up, Judge, and that's what you need to understand, and we'll treat it differently because of that. All right? Thank you, Mr. Rhodes, for bringing all these resources to bear.
I'm sorry, I didn't hear the last.
I thanked you for bringing all these resources to bear. It was a very impressive presentation.
Thank you.
Mr. Weish, did I pronounce your name correctly? So if I go through you, you can get in touch with Youth Build? Because it doesn't say Youth Build on here. It's a different, it's Adoles or something. Okay, so if I'm encountering someone who seems like, hey, this might be a good fit, especially if it's someone who's out on bond, then by calling you, we could figure out how to connect. Okay. Have you ever spent time with any of the social workers from the public defender's office? Okay, I may arrange that if that doesn't bother you, because I would love for them to have this program in mind when they are encountering, because I didn't get the sense, I don't mean to suggest Mr. Rhodes wouldn't have done this, that it was his idea, hey, let me connect. He came in too late, meaning, Mr. Willingham was already in custody, but we get young men who aren't in custody because they got a bond or it wasn't quite this serious, who would benefit so much from this opportunity. And to have the public defender's office knowing, hey, here's a program, Judge, if you give my guy a bond, it doesn't involve guns or this or that, he's been accepted into, or he would be considered by, that would be a great resource. Okay, we'll make that happen. Thanks for your time. Hewley?
Yes, do we have time?
We do. We'll try to do Hewley and Roberts.
It's really important that I get out there. My mother and my grandmother sit in the house by themselves.
Okay.
This whole morning.
Um,
I'm trying to get it.
Well, and we got to take care of Roberts. We can't not do Roberts. That has been made clear to me. I just have to be on this van with Lee Feely and 8 litigation managers out to the jail at 12:40. So how long do we think Roberts will take? Okay.
I mean, it's a plea. And
Yeah. I just don't know what he's like.
He's fine right now.
Okay.
That's why.
Ms. Wood, if we do him first, is that okay?
Just let the family know that it'll be this afternoon.
It may be. We'll see if I can fit both things in, okay? Do you want to connect on Zoom or you want to be in person? Is Hewley a non-negotiated plea? It's a negotiated plea. So there's, okay, is the family here to, I see you here to contest it, or does they want to hear it happen? Okay, and you're entitled to do that. I have a hard stop at 12:35. I'll be back at 2:30. We're gonna do Roberts first. If we can fit Mr. Hewley in, we'll do that. If we have to move it to 2:30, we gotta do Roberts. Yeah, I just wanna play all this out. You're welcome to stay. If we can fit it in before I have to go, we'll do that. Otherwise, we'll do it at 2:30. You're also welcome to be here for that. If you are sick and tired of waiting, Ms. Wood can get you the Zoom link so that you can see and hear however he's related to you, your husband, son, whatever he is. He'll be right there on the camera and you'll be able to see and hear everything that happens. So I'm not telling you gotta go. I just want to manage your timing expectations. Okay, great. I apologize. You see, we've been trying to make stuff happen. It's been one of those days.
I'm not either.
Ms. Rios, a relative of Mr. Denike has been on this call and is walking around. Do you want to let him know? Okay.
Family and let her know that.
We can talk tonight, this afternoon, if there's going to be a conversation. It's not going to be before we have to break. Yes, please. Hey, Mr. Roberts, come on up to the podium, please. All right, we're going to get on the record. We have Mr. Eugene Roberts here with his lawyer, Ms. Cabrera. Ms. Smith is representing the state, and we are handling for plea 25 SC 004848 and 25 SC 005788. And I think there's a revocation we're going to take care of as well. Mr. Roberts, I've been told it's a global plea, meaning I'm making this up, but if you're pleading to a year, the revocation is going to be the same length. So this all going to roll into one. I just don't know the revocation number. I'm sure it's on the screen somewhere and I'll get that, but we'll handle the revocation as well. Is that your expectation?
Yes, sir.
Good. That's what we're going to do. In just a moment, Ms. Smith is going to put you under oath. Once you're under oath, please answer her questions truthfully and completely. And let me know if at any point you have a question. You're not understanding what's going on or it's not going the way Ms. Cabrera told you it was going to go. Tell me and we'll talk through that, okay? All right, Ms. Smith.
Yes, Your Honor. Mr. Roberts, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
Eugene Roberts.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
And is there any medication that you would normally take that you haven't been given this morning? How old are you and how far have you gone in school?
25. Went to the 11th grade.
Where'd you go to high school?
Washington High.
Okay.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Oh, yes, ma'am.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Oh, yes, I have.
Do you need more time to discuss your case with your attorney?
No.
And are you satisfied with her services?
So far, yeah.
Counsel, are you satisfied your client has a full understanding of this proceeding?
Yes.
Do you waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
So
Mr. Roberts, do you remember being arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants related to these charges?
No, ma'am.
No.
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 10 years to serve 18 months with the balance probated?
Yes, ma'am.
Speak up.
Yes, ma'am.
Are you aware that the court does not have to accept that recommendation and that the court can sentence you to the maximum on each charge and can run those sentences consecutively, meaning one after another?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, You cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence.
Yes, ma'am.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, even on a federal case?
Yes, ma'am.
Are you currently on probation?
Yes, ma'am.
Do you understand that if you're currently on probation, your probation may be revoked based on you entering this guilty plea here today? Yes.
Yes, ma'am.
And are you a United States citizen?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? And that includes your guilty plea may affect your right to vote, your right to hold public office, the right to serve on a jury, the right to obtain a passport, or the ability to obtain employment.
Yes, ma'am.
Do you also understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm, and that if you did, you could be charged with another felony offense?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Counsel, are you satisfied your client understands that these are the rights that they'll be waiving by entering this guilty plea?
I am.
Mr. Roberts, has anyone forced, threatened, or promised you anything for you to enter into this guilty plea today?
No, ma'am.
As to indictment number 25 SC 004848, how do you plead to count 1, theft by receiving stolen property, and count 2, theft by extortion?
Yes.
As to indictment number 25 SC 005788, how do you plead to count 1, entering automobile or other motor vehicle with the intent to commit a theft or felony, possession of tools for commission of a crime, financial transaction card fraud, financial transaction card theft, and possession of a firearm or knife during the commission of or attempt to commit certain felonies?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you do not have a right to appeal directly from your guilty plea? But if you believe that there is some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
Yes, ma'am.
Do you understand that that has to happen within 30 days from today?
No.
Do you understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Thank you, Mr. Roberts. Your Honor, if this case were to proceed to trial, and I'm going to start with the indictment ending in 4848. The state would have shown that on September 21st, 2023, Officer Raymond with the Atlanta Police Department was dispatched to 1183 Oakland Lane, Southwest Atlanta, Georgia, happening in Fulton County, where he was responding to a theft call. When he got to the scene, he made contact with Mr. Jared Charles Major, who stated that on September 21st, 2023, his 2016 Land Range Rover bearing the tag CIHI 641 was broken into, and pieces of his or different property of his was stolen from the car, including a black Louis Vuitton book bag, an iPad, an iPhone, and a .380 firearm. At this time, Mr. Garrett or Mr. Majors was able to track down the location of the iPad that was stolen from the vehicle. when the police officers with Mr. Garrett's help was able to track down that iPad. The person who had it was Mr. Eugene Roberts, who is the defendant in this case. He told the victim that the iPad that he had, he purchased it from a friend for $125, but that he would give him the iPad and other items stolen from his car back if he would pay him a certain amount of money. At this time, the officers responded to that location, and they spotted the defendant, who then attempted to run away from the police officers when he saw them. After a brief foot chase, the police officers were able to detain Mr. Roberts and arrest him for the charges. We have an indictment ending in 4848, and those are the facts of that indictment. Regarding the indictment ending in 5788, Your Honor, this case were to proceed to trial, the state would show that on June 11th, 2025, officers responded to 1240 Oakland Drive Southwest, that's in Atlanta, Georgia, and also Fulton County. When the officers got there, they spoke with the victim, who stated that they parked their 2018 Ford F-150 at the location, and it was broken into, and their gun was stolen, as well as their social security cards, driver license, gun permit, and debit cards. The victim in this case name is Menzo Aquino. I'm going to spell that. Munioz, last name Aquado. The officers were able to track down the defendant in this case, along with another person who was using the debit cards at a package store at 1097 Lee Street that was on Avery Pie. At this time, Your Honor, when the police officers responded to that location, they were able to speak with the clerk, who said they had security and surveillance cameras of the defendant along with someone else coming into the store using those debit cards that was owned by the victim. The victim also was able to recover their social security card and ID card from the store after the officers were able to identify that is where the defendant and another person was that was using their card. At this time, the police canvassed the area for the defendant. He was found and arrested for the charges that we have in front of us for indictment ending in 5788. And those are the facts of that case, Your Honor. Regarding the negotiated plea between the state and the defense, we've agreed to a global offer of 10 years to serve 18 months with the balance probated. As far as the special conditions of probation, the state is asking for restitution to be reserved. In one of these cases, we have received the receipts and proof of the restitution, but not for the other case. We're still working with the victim to get that number. However, we are asking for the restitution to be reserved, for the defendant to complete an anti-theft course, and for the defendant to be gainfully employed and show proof every 90 days. And this is for both indictments to run concurrent with each other, along with the probation revocation that I think we will do afterwards. That is all from the state, Your Honor.
Got it. Okay. And as for criminal history, sounds like 7 cycles. Okay. And on probation for one, is it only one felony conviction? Yeah. 2. Okay. What?
Assault, possession of a knife or firearm, for possession of cocaine.
Okay. So ag assault, 1 conviction, drug case, other conviction.
That's one case.
Oh, all 1. Okay. Okay. Are they both Fulton cases? Okay. How much time remains on those?
So the first one is docket 24 SC 002250. That balance is 2 years, 9 months, 5 days.
All right.
The second docket is 24 SC 002307. That balance is 7 years, 9 months, 6 days.
Got it. Okay. Ms. Cabrera.
Yes, Your Honor, I will keep it simple. This young man is 25 years old. He does have a daughter. We had an opportunity to speak about this. He had a couple questions about how this would work. Would Your Honor allow it to run concurrently? And so I let him know that that's the negotiation, but that is up to you. I'm just asking that Your Honor accept the plea as negotiated, and that when we get to discussing probation, that the recommendation of probation that he serve the 18 months be allowed to run concurrent with the sentence.
Got it. Okay. Mr. Roberts, how old is your daughter?
3 years old.
What's her name?
Her name Naji.
Nija?
Naji.
How often, I guess you haven't seen her for a little while.
Really, almost on an everyday basis.
Oh, you check in with her each day?
Oh, you talking about from in jail?
Yeah.
Oh, almost on an everyday basis.
Okay, good. All right. Is there anything you want to share?
Not really, not really.
Okay. All right. Well, Mr. Roberts, I find there's a factual basis for both your pleas. One case a long time ago, 23, and the other much more recent. The 23 case isn't a basis to revoke the probation. It would be the case ending in 788 that would be the basis to revoke, just so we get the paperwork right. Okay. I also find, Mr. Roberts, that your pleas are knowing and voluntary, meaning you've understood what we talked about, and no one's forcing you to enter these pleas. Is that correct?
Yes, sir.
Okay, then I'll accept them. Ms. Cabrera, can someone in my office sign the 2 indictments for you?
Okay.
Ms. Smith?
Yes, Your Honor.
And Mr. Roberts, can we electronically put your signature on the 2 indictments indicating your guilty plea?
Yes, sir.
I'll do that. We will hold off on restitution. If the state comes back and asks for a hearing on that, we will do that. So I'll leave that open. What I'm going to do in the case ending in 848, so 25 SC 004848, I'm sentencing you on count 1 to 10 years to serve 20 months with the balance on probation. Special condition of probation number 1 is you complete an anti-theft course. Number 2 is you get your GED. And then number 3 is that after you've been on probation for 60 days, you provide proof of employment. And for each month that you're not employed, after those first 2 months, you will need to do 60 hours of community service if you're not working. If you've got a job, you don't need to worry about community service. If you're not working, then you give back to the community in some way. Your sentence as to count 2 is the same, so they'll run concurrently with each other. In the other case, ending in 788, count 1 is 5 years to, make sure I get these counts right, is 5 years to serve 20 months with the balance on probation. Count 2 is 5 years to serve 20 months. Counts 3 is the same, and 5 is the same, and then 6 has to be 5 years, and it has to run consecutive to count 1. So the total sentence for the case involving the F-150 is 10 years to serve 20 months with the balance on probation. Same special conditions, anti-theft course, GED, and you need to be working after you've been on probation for 2 months. I will handle your revocations as follows. In 24 SC 002250, because of your conviction in the case ending in 788, I'm going to revoke 20 months and suspend the balance. So that case will be closed out. In the other case, which is the burglary, 24 SC 002307, I'll also revoke 20 months, but reinstate the balance. So you're going to have 3 cases for which you're on probation and 1 I just closed out. Everything runs concurrently, so all those clocks are running at the same time, and we'll reconnect if we need to about restitution. Did I miss anything you were concerned about?
No, Your Honor.
Okay.
But in his original, when he was originally sentenced on both cases, the revocation cases, he was judged, requested a non-health officer and for some kind of way that got missed.
Okay.
So can we include that as a condition?
Sure. Yes, sir.
Oh yeah, with that situation, they just came and talked to me like a week ago. I never knew I had to go to Grady.
Okay, you're not sideways for not going to Grady. We'll No one's asked for an evaluation, so I won't do that. But what we'll do is assign a mental health probation officer. That person, when he works with you, may after a while say, hey, I need you to go meet with someone at Grady, and let's see if you taking some medication or getting some counseling would help. But that'll be up to you interacting with the probation officer. Okay? Ms. Cabrera.
Yes, so since it was different, I just wanted to explain to him what was different.
Yes, sir. So Mr. Roberts, I'll explain it and then you and Ms. Cabrera can talk about it. Your lawyer had negotiated 18 months. I upped it a little bit to 20 as I heard more about it. It's a lot of cases. You were on probation for 2 cases when it happened. I actually think 2 years is probably a better fit, but your lawyer was pulling in the other direction and the state agreed with it. So my sentence was a teeny bit more. You're still getting credit for all the time you've been in. But if you want to back out and say, no, I'll go to trial over all this, over the 2 months, you've got the right to do that. You just needed to understand that my sentence reflected what I thought was a little more serious than how it got negotiated. You have any questions about that?
No, sir.
You're good going forward?
Yes, sir.
Okay, then we're done. Ms. Simpson's gonna come talk to you. She's gonna let you know you gotta report to probation when you get released. You know that anyway, but you'll need to, within 48 hours of your release, you'll need to report back to probation.
I guess so.
Okay, good luck.
Thank you.
Thank you, Ms. Cabrera.
Thank you. I had a running. Oh, no, you don't.
So I don't think we'll fit in a plea before I have to go, but let's talk about how we're gonna structure when we get back. And if you wanna be back at 2:15, I think Ms. Feely had to be back anyway. I bet I'll be, I don't wanna make people wait, and so I'll wait. But if you're here at 2:15-ish, I'm happy to get rolling. But the commit time is 2:30. We have a plea with Hewley. We have a plea and revocation with Wilson.
Correct.
Okay, and then from the trial calendar, we should still have, we'll see what happens with Twitchell. I'm happy to talk to Mr. Denike if we need to do that. In fact, I could do that right now because we have that window. We've got Mr. Flagg, 2 pleas.
Yes.
Ms. Scott, that did work with, I mean, she's in the queue. Jamal Lewis turned into pretrial diversion. And then Tremaine Scott said, no, thank you to his offer.
We also have a, can he ask you?
Oh, right, that revocation.
Yes.
Okay.
Time served agreements, I hate.
We could do that. I got 10 minutes.
Okay, let's do that.
Okay.
Yeah.
Do you guys want the Zoom link? Is that gonna be the most practical thing? I'm sorry we didn't fit it in, but you should log into Zoom, and if for some reason there's something you need to share, you can even share it through Zoom, but it sounds like everyone's on the same page with this one.
Yeah, you're in a number. Thank you. Yes. Actually.
Yeah.
Ask
You. He pled to whatever he did in Rockdale, and that's over and done with, is my understanding.
Or it was late, right? I think it was, cause here.
Hey, Mr. Askew. I'm okay. All right, let's get it on the record in your matter, and round things out. This is 22 SC 183736. And Mr. Askew is here with Ms. Rios. We have Ms. Smith for the state. And Mr. Askew, we are together because you had an issue with probation. I signed a petition that alleges that you, in July of last year, committed a new crime in Rockdale County related to having a gun and reckless conduct. You also were a little behind in your fees and fines. In fact, you're 100% behind. You hadn't made any payments at all. I'm more focused on what happened in Rockdale. But I think I received word from probation, you've already resolved those charges, which doesn't mean that's good with probation. It just means you dealt with that. I'm gonna ask your lawyer what your approach is to this. I'll hear from the prosecutor and from probation, and we'll figure out what we're doing, okay?
Yes, Your Honor, we're stipulating to the violation. He pled to that.
What did he plead to?
10-3, that was the
10-3.
yes.
Okay,
With work release program, which I was actually in when they arrested
Yes, he was
me.
in a work release program
For
that
2
he,
months.
for 2 months. And so I believe the agreement is for him to have time served and go back to the work release program that he was in Rockdale. He's working as a maintenance man through that program.
okay. Let me find the paperwork. So you only have a little bit left in this case. You have 9 months left-ish. And what I have is that you were sentenced to 10 years probation in Rockdale, but you said 10-3.
It was with the stipulation that I finished the work release program.
And if you do that, the 3 years are not prison time. So there's a good incentive for you to do the work release program.
Which I was doing for, they locked me up in the.
Okay, for this. Okay. Is the work release program a county program or is it through an agency or?
Through probation.
Okay. What is probation's work release program?
That's got to be through Rockdale because we don't have one.
Okay. We should. Okay. How long has Mr. Askew been in here? Like 12, 13 days?
A month, I believe. And
Oh, this is an older calendar, I guess. Okay. So you're requesting effectively revoke 1 month and reinstate the balance or close this out?
closed it out. Let me just double check, make sure he was.
Yeah,
we
we
were
recommended
balance.
terminate balance, because he still has an extensive.
With Rockdale, he's got plenty of time there. Okay. Okay, yep, 32 days. All right, Ms. Smith, your thoughts?
Yes, Your Honor, the state is in agreement with the revoking time served and terminating the balance in this case.
Okay. Mr. Askew, we're gonna miss you. We're closing out your Fulton case. You're just gonna have Rockdale business. Where's home for you?
It will be here.
Oh, in Fulton?
Yes.
Oh, so you'll be back. Where are you doing the work release?
It'll be in Rockdale, but I work and they let us travel every morning. We leave at 5 o'clock. We had to come back at 8.
Oof,
I
okay,
was doing that for 2 months.
okay.
Yeah.
Does that mean, are you like in a halfway house or are you staying at home?
It's actually, I sleep at the jail.
Oh.
Jail every night at 8 o'clock. What they do,
Oh, so you go to Rockdale County Jail at night.
Mhm.
Your work happens to be in Atlanta.
Yes.
Okay, yeah, we definitely don't have that program. Deputy Gordon says, whew, okay. So, you go home, to speak, to jail, work during the day, back to jail, but you get through that, then you're just on probation.
Yes.
And home will be back in Atlanta or Fulton County.
Yes, sir.
How much more work detail do you have?
I got till May 5th.
Okay, all right, so 3 months.
Yes, sir.
All right. I will revoke 1 month of your probation. You'll get credit for time served. I will terminate the balance of your probation. So when you are released, this case is closed out. You remain on probation out of Rockdale in the work release program. Don't change any of that. I'm not touching that at all. I'm just, as a result of your Rockdale arrest and conviction, you had a 1 month revocation here. Fulton case is closed out and you are off to handle things with Rockdale.
Thank you, sir.
Who's here in court for you?
My
Is that a special friend?
fiance.
Your fiance. All right, she's been here all morning. All right, good luck, Mr. Askew. Don't mess up this opportunity Rockdale gave you.
Thank you, sir.
All right, thank you. Pardon?
If you don't have a lot of time, I can just talk to him.
I don't mind, I can talk to him for 5 minutes.
Okay. You'll get it later.
And then you got Mr. Buddha.
Oh.
Absolutely, please. Is he up? Don't worry.
Oh, so he's good, right?
Yeah, yeah.
Okay. So you.
When he be pretty nice to go, wasn't county to go to Rockdale?
I think, I don't know how that works.
Yeah, how would it work with work release? Will he just be released from Rice Street or will he be shipped back to Rockdale, you think?
They took him out of the jail, so it's not, he would have to report to the probation officer.
Okay. Well, certainly if he gets released from Rice Street, he better go straight to his probation officer. Okay. I can't believe they brought him over. Why is he still here?
Judge, that is a wonderful question.
Are you getting phone calls?
Yes, I am. Because it's my fault that he's still here.
Uh-huh.
Okay.
He is lucky to be alive, as best I can tell. Mr. Tonight, come on up to the podium, sir. Right up here. How are you?
Good, how are you?
I'm all right. I wanted to give you an update. I have been putting your case on every calendar I can find. We have a judge who comes in 2 weeks every month to try some of our older cases. You're on that. You are actually number 4 on that list for next week, but you're number 4, and I think one of the ones ahead of you will go. You're number 2 on my list. We've got someone who's been in jail a whole lot longer than you have, who hopefully will be going to trial for this calendar. If he doesn't, you're the backup. So I just want to let you know, no one has forgotten about you. And your lawyer continues to press the prosecutor to see, hey, maybe there's a way we could work this one out. So that's still in the works, but that's really a decision that the prosecutor has to make. And I just say, let's be ready when we reach the case. So you may be brought back here, not this coming Monday, but the Monday after. That's when we're doing trial. If you are, that means that you are the backup and we may get to your case, okay? If not, I'm gonna add you to my next calendar and I'll keep putting you on that calendar that I get to put cases on with the senior judge. Any questions about that? No? Okay. Good seeing you.
Good seeing you.
So, for Ms. Rivers and our pretrial team, if you can be back here 2:15-ish, but that's a soft 2:15, I hope I'll be back from the jail by then. This should be a quick visit, and we're not going into detention.
Thank goodness.
But 2:30 would be the official start time. But if you can sort of be easing back in, the earlier we can start, the better. We'll get through everything. Now I see what's left. It's not a million things. Everything took a long time this morning, partly because we couldn't get people up. Yeah. So I will see you guys between 2:15 and 2:30. Thanks. Yeah, so we're gonna start doing 2 of the non-complex calendars out in courtroom 1 in person. Judges will be there, lawyers will be there. It's not an option. They were told.
Like everywhere.
All right, welcome back, everyone. If you could text Mr. Abadi, Mr. Apt, Mr. Twitchell's lawyer, is actually in the building now. He's in another courtroom, but will be working his way here. So if we could get Mr. Abadi here next few minutes, that would be great. In the meantime, what would you like to do next?
Jerry, please.
Hewley, please. You've only asked about 11 times for that one. At least you're consistent. Like, wait, what? I thought we were doing something different. Oh, he's right here. You were just being texted. Mr. Apt is here. He is in Judge McAfee's courtroom, but come in here next.
Did he give it each day? I think I have 5 minutes to run back.
You have 5 minutes. We're taking a plea right now anyway, and he's gonna need to talk to you after he talks with his client. Yep. Mr. Hewley, good afternoon.
Yes, sir. Good afternoon.
Good to see you. We are going to get on the record in your case in just a second. I need to confirm because we've been down for a little bit. Ms. Rivers, you good to go?
Yes, I'm ready. Good afternoon.
Before we get started, Ms. Rivers, they got a guilty verdict in the trial that you took down on Tuesday. And when the guilty verdict was announced, the defendant's family started screaming at the jurors and the victim's family and had to be thrown out of the courtroom.
Oh, my goodness.
Yeah.
I'm not surprised at the verdict.
Yeah, no, the way Judge Emerson was describing it, my guess is they deliberated for about 20 minutes. It was
Media case?
It was.
Okay.
Yep.
All on video.
Yep, all on video. And so why the defendant's family had trouble processing it, I don't know, but they got real out of control and that got messy. The jurors were afraid to leave the building. But that's not here. We are taking a plea. This is position 5 on our add-on calendar, 26 SC 000141, State versus Jerry Hewley III. He is here. Oh, this is a Willingham case.
Yes, it is.
You're deputized. Excellent. Okay. Mr. Hewley is here with Ms. Wood, and Ms. Smith is handling the case for the state. And Mr. Hewley, you should know that you had 3 friends or family members here all morning long to be here for your plea. We just weren't able to get to it this morning because, as you saw, there were a million moving parts. And by the time Ms. Wood was able to get you in line, actually, she got you in line plenty of time, but by the time we could get to your case, it was break time. So I acknowledge that you had family here, and they have the Zoom link, so they may be listening in, but they were here for you. So with that said, in a moment, Ms. Smith will put you under oath. When you are under oath, you need to answer all her questions truthfully and completely. If you have questions of your own, you need to, oh, here's someone back. That was one of the people who was here all morning.
Thank you, sir.
You need to let me know if you have any questions at any time. Will you do that?
Yes, sir.
Okay. Ms. Smith?
Yes, Your Honor, thank you. Mr. Hughley, could you raise your right hand, please? Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
Jerry Bernard Hughley III.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am, not at all.
And is there any medication that you would normally take that you haven't been given this morning or afternoon?
No, I took my medication. I just take a muscle relaxer for the old wounds that I have playing football.
How old are you and how far have you gone in school?
I'm 36 and I went all the way to the 12th grade and I dropped out of school from there.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes, ma'am.
Do you need more time to discuss your case with your attorney?
I just wanted to ask a question, but no, I could ask the judge.
What's the question about?
Sir, I had I think a probation supposed to be over with that I had previously, but I don't know that I still have probation.
We'll definitely talk about that.
Yes, sir.
Okay.
Counsel, are you satisfied your client has a full understanding of this proceeding?
I am.
Also, do you waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
We do.
Mr. Hughley, do you remember being arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants related to these charges?
We are not.
Okay. Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 3 years probation?
Yes.
Are you aware that the court does not have to accept that recommendation and that the court can sentence you to the maximum on this charge? Yeah, and can sentence you to the maximum on this charge.
Yes, ma'am.
Okay. Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand that if you're charged with another crime in the future, that this plea may be used to enhance that sentencing, even in a federal case?
Yes, ma'am.
Are you currently on probation?
Yes, I think I am. Yes, ma'am.
Do you understand that if you're currently on probation, that your probation may be revoked based on you entering this guilty plea today?
And yes, I do. And that's what I'm trying to see before I want to accept the guilty plea.
Well, let's figure out, do you, Ms. Simpson, have any information about Mr. Hughley on probation?
Yes, Judge, he is on probation. This case would have put him in revocation, but it's already been resolved with Judge Richardson on October 17th of 25.
Meaning she had a revocation hearing that was predicated on this conduct. What's that case number?
23 SC 190543.
Okay. How much time is left on that?
He currently has 3 years, 8 months, and 2 days.
Okay.
Yeah, that's what this will do. It'll go along with that one.
Yes, ma'am.
2 days remaining.
He has 3 years and 8 months remaining. There may have been some days, but 3 years and 8 months.
Thank you.
Sure. Mr. Hughley, your concern is understandable. I'm going to look at the case from Judge Richardson in just a minute, but what Ms. Simpson has explained is that yes, picking up these new charges is a problem for someone on probation, but you and Judge Richardson already dealt with that, and she did whatever she did. She revoked time or reinstated your balance. I'm going to see what her order was, but you have already dealt with the probation consequences of what you did to Diamond Johnson in May of this year in your old case. Okay?
Okay.
That makes sense?
It don't what it do. It basically it's saying that they're gonna merge it together concurrently.
Two different things. Your first question to me was, hey, am I going to get in trouble with probation for taking this plea? Short answer, no. Because you already did get in trouble with probation, and you were in front of Judge Richardson in October of last year, and she did whatever she did. So no, you're not going to get in any more trouble. Your other question was, well, hey, Judge, you're going to give me this sentence. Can it run at the same time as my other sentence? Short answer, yes.
Okay.
In fact, they will run at the same time.
Okay.
Okay.
I have one more question.
Sure, you have as many as you need.
Do it mean that I'm going home today, or do I have to?
I can't tell you that yet. I need to hear everything about the case. If I go along with the recommendation, then you're probably going home tomorrow. You probably won't get out today. Things don't move that fast. But I could hear about this and say, no way, man, this is Hughley's second or subsequent family violence battery. He beat up Miss Johnson. I may say, you need to do 6 months in jail or something. And you could say, whoop, that's not what I signed up for. You could back out of the plea. Because if my sentence is more severe than what Ms. Wood has negotiated for you today, you can back out of it.
Yes, sir.
All right? But if I go along with it, then you have a sentence that is just probation. You might not get out today. You might get out tomorrow. So if you're banking on, I'm leaving in 20 minutes, that's a bad bank.
Yeah, no, I'm not banking on that.
Okay.
Yes, sir.
All right?
Mr. Hughley, are you a United States citizen?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, or the ability to obtain employment.
Yes, ma'am, I do.
Do you also understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm? And that if you did, you could be guilty of another felony offense.
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering this guilty plea?
Yes, ma'am.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Counsel, are you satisfied your client understands these rights that they'll be waiving by entering into this guilty plea?
I am.
Right. Mr. Hughley, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea today?
No, ma'am.
As to indictment number 26 SC 000141, how do you plead to count 1, battery, family violence, subsequent conviction, or prior forcible felony conviction?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you do not have a right to appeal directly from your guilty plea? But if you believe that there is some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
Yes, ma'am.
Do you understand that you have to do that between today and within 30 days?
Yes, ma'am.
Do you understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this plea?
Yes, ma'am.
Thank you, Mr. Hughley. Your Honor, if this case were to proceed to trial, the state would show that on May 10th, 2025, at approximately 3:43 a.m., officers of the East Point Police Department responded to a fight reported at 2983 Kentucky Court, East Point, Georgia, that's occurring in Fulton County. Upon arrival, the officer made contact with the victim, Diamond Johnson, who appears to be in distress and had visible injuries on her body. Ms. Johnson reported that her ex-boyfriend, identified as Jerry Hughley, the defendant in this case, arrived at the location unexpectedly and started arguing with her. This altercation then became physical when Mr. Hughley assaulted her, striking her in the face. Ms. Johnson sustained visible injuries, including a busted and bleeding lip and slight swelling on the left side of her face. When asked how Hughley knew that she was at that location, the victim stated that she did not have any knowledge on how he was able to find her. She confirmed that they were in a relationship for about 4 years and did live together, but they were not together on the day that this incident happened. Because of that, the defendant was arrested and charged with these charges we have in front of us. Those are the facts of the case. Regarding the negotiated plea between the state and the defense, we've agreed to a sentence of 3 years probation for the charge. Regarding the special conditions of probation, we're asking for no violent contact with the victim, for the defendant to complete the family violence intervention program, also for the defendant to complete 60 hours of community service and seek and maintain gainful employment. Also, there's a note that Ms. Willingham did speak with the victim last week and that she wants no violent contact with the defendant in this case, but is not opposed to him being released. And that is all from the state, Your Honor.
All right. So Mr. Hewley was supposed to do family violence intervention program with his other case. Have you done that yet?
Yes, I completed it.
I don't have proof, Judge, but he did tell me that. I explained to him, that's part of our negotiations. I believe it's required by the statute for him to do another class.
I have no
So-
problem with it.
Okay, well, we'll see. I don't have a problem with it, but if you have a certification, well, I'll come back to that. I just wanted to flag, look, I was looking at the conditions of probation because Mr. Hewley had 2 probation violation orders in the older case, the victim of which was Diamond Johnson. So here we are again. Okay. Let me check one thing. If we're talking about criminal history, it sounds like 18 cycles for Mr. Hewley. And we've got the open, meaning he's on probation for a case. And then how many other felony convictions?
Robbery, 2012 robbery, first offense.
Okay, great. Ms. Wood.
Judge, Ms. Johnson is present in court. I've spoken with her as well, and exactly what Ms. Willingham shared is what she shared with me. My client is 36 years old. He is a lifelong Atlanta resident. He has a 12th grade education, he has 3 children. He was gainfully employed at the time of this incident as a lead cook at a restaurant, and he also has an HVAC certification, Judge. He's actually been in custody 227 days. So we would just ask that he receive that credit. Otherwise, we would ask that you accept the state's recommendation.
Mr. Hewley, you have 3 kids. How old are they?
10, 4, and 6.
Why do you list them in not numerical order?
It is because I did the 2 boys first and then.
Okay, boys before girls.
And,
All right. Is Ms. Johnson the mother of any of your kids?
No, I have, my stepdaughter is from Miss Johnson, and it's her child alone. But I've been raising her ever since she was 10 months.
Is that the 6-year-old you're talking about?
Sir.
Okay, so 10 and 4 are your biological children?
Sir.
And the 6-year-old is your stepdaughter. It's Ms. Johnson's biological child.
Yes, sir.
When you get out, where are you going to live?
With my mother, the woman who came today, Valencia Moore.
Is that in the Atlanta area?
Yes, the address I gave her.
I don't need the specific address, but it's in the Atlanta area?
County, yes, sir.
Okay. Why would you need to spend any time with Ms. Johnson?
Actually, I just want this whole thing to be over with, sir.
What's this whole thing?
If the relationship and everything with it, sir. I just want to get closer to my kids because I miss them.
Okay, but you listed 3 kids, one of which you kind of share with Ms. Johnson.
She's gonna always be a daughter to me, sir.
Okay, but if you're spending time, what's her name? The 6-year-old?
Kalani.
Say it again? Kalayan?
Kalani.
Kalani.
Yes,
If
sir.
you're spending time with Kalani, then you're going to be interacting with Ms. Johnson.
Yes, sir. I know that right now I'm trying to get there with my kids, build a relationship with them, and we'll see how things go in the future. I just don't want to have no more problems with Diamond Johnson or anyone.
Okay. Ms. Johnson, what Ms. Smith shared with me is that you have asked for the condition to be no violent contact, which is what I would want as well. I don't want anyone hitting me or busting my lip. But you are very much in a position to say, I want no contact. Mr. Hewley has done these things to me and I want him out of my life. But I'm not hearing you say that. Is that correct? Okay. Could you tell me why if you don't mind coming a little closer, because I need the court reporter to be able to hear you. If you can just stand next to the gentleman right here. Tell me why you feel comfortable or safe having Mr. Hewley around.
We're no longer in a relationship, and I stayed in a separate home for him, and I mean, he's been good overall. He keeps in contact with my daughter.
Okay.
She got her own home, she home, and when he comes home to his kids, they ask about his father.
Okay.
He's trying to get his life together. He was working on his classes and stuff. He was actually doing to them. despite the incident that's supposed to happen. I don't know about the busted lip and stuff. We did get the argument, a lot of argument that caused that happened that day.
Yeah. Officers don't tend to make that kind of stuff up. They're just, look, this lady is talking to me and she's bleeding from the lip and she's got a bruise on her face.
I didn't have a busted lip.
Okay.
It just was a chaotic day.
It was a chaotic day. It sounds like it, because if they were there at 3 a.m, that's a chaotic day.
I had came from the club, maybe I came to his personal area, he wasn't there. But he got there, we got into a loud altercation with the neighbors came outside and they called the police.
Okay. You mentioned that he's trying to be with his kids. Do you take care of the two boys also? Do they stay with you or they're somewhere else? Okay. Okay. That's who was here.
That was his mother that was here and his stepfather.
Okay. Got it. Okay. All right. Well, I appreciate you sharing that. Mr. Hughley, anything you want to add?
No, sir.
Okay.
I'm just tired.
You should be. You spent a lot of time in jail between this case and the other one that you're on probation for, where Ms. Johnson was again the victim of you not managing your relationship in a real safe way. Well, I find there's a factual basis for your plea, and that your plea is knowing and voluntary. Voluntary meaning you've decided this is what you want to do. No one's forcing you to plea. Is that right?
Yes, sir.
And knowing means you've understood what we talked about, or you had questions like you asked. Do you have any other questions right now?
No, sir.
Okay, then I'll accept your plea. Ms. Wood, can someone in my office sign the indictment for you?
Yes, sir.
Ms. Smith?
Yes, sir.
And Mr. Hughley, is it all right if someone in my office electronically signs your name to the indictment indicating your guilty plea? We will do that. What I am going to do, Mr. Hughley, is sentence you slightly differently. I'm going to sentence you to 5 years to serve 7 months with the balance on probation. But you're going to get credit for the time you've served. So you're still going to get out, probably not today, but tomorrow. You're going to have a little more probation because I want there to be more room to work with if we're together again in 6 months or 9 months and there's evidence that you hurt Ms. Johnson.
Yes.
Okay, or anyone else in your life. I'm not picking on her. You may have someone else important in your life. And if the family violence intervention program hasn't helped, and when you get upset, or maybe you've had something to drink and someone else has had something to drink, you do something that hurts them, I want as much probation as I can have to say you need more time away from family because it's not safe yet. But if you're tired and ready to do things differently, then probation is not going to be a problem for you. You're going to work, you can take care of your kids, and it's not an issue. So 5 years to serve 7 months, balance on probation. Special condition number 1, no violent contact with Ms. Johnson. So you can call her, you can write, you can be around her. But if you start to feel like you're getting frustrated or upset, you just got to walk away. You'll need to do 60 hours of community service. That will be within the first 8 months of your probation. I'm going to require that you complete the family violence intervention program unless you can provide proof that you already did. You don't need to do it twice. It might not hurt to have a refresher given this case, but if you've already taken it, it's a bunch of classes and it's expensive and you got people to take care of. So if you can get proof of completion, then I'll waive that requirement. And finally, you need to be employed, which I know you want to do, but if you are not working at least 20 hours a week after your first 2 months of probation, then you're going to have 10 hours a week of community service until you are working at least part-time. Make sense?
Yes, sir.
Ms. Smith, anything else in the Hughley case? Thank you for filling in for Ms. Willingham. Ms. Wood, anything else on behalf of your client?
No, Judge, thank you.
Mr. Hughley, Ms. Simpson, who is in the red right there, is with probation, and she needs to give you reporting instructions because you're going to need to reconnect with probation. I didn't say this, but it happens automatically by law. Your sentence in this case is going to run concurrently with the probation that you already have in that other case. So those clocks are running at the same time. So you're only going to have one probation officer. You only have to report in connection with one thing. It's just 2 different cases, one with Judge Richardson and now one with me. Okay?
Yes, sir.
All right. I think Ms. Simpson may go talk to you back there.
Good luck to you. I don't want to stand back in the south.
Yeah.
Okay. Good luck.
Ms. Wood, would you like to do Mr. Flagg?
Yes.
Okay, we'll do that. Mr. Apt, after we take Mr. Flagg's plea, I'm going to turn to you and Mr. Twitchell to see whether he goes on the short list for the actual trial week is the 23rd. It's not next Monday, but the week after. So assuming, I don't know where we fall on your list of obligations. Eventually this case will be so old, it would be number one regardless, but we'll talk about that after we take the flag, please.
Thank you.
Hello, Mr. Flagg.
Hey, sir.
So we're going to get on the record in your two cases. It's 25 SC 003-801 and 25 SC 005-371, both burglary cases. You are out here in court with your attorney, Ms. Wood. We have Ms. Smith for the state. And Mr. Flagg, Ms. Wood tells me that you're ready to enter a plea in your two cases. Is that right?
Yes, sir.
Okay. Ms. Smith will put you under oath and go through the usual questions about your rights and some information about you. If you have questions at any point, will you let me know?
Yes, sir.
Okay. Ms. Smith?
Thank you, Your Honor. Mr. Flagg, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
No, I do.
Okay, the Lord. Please state your true, correct, and legal name.
What you say?
Please state your true, correct, and legal name.
My real name is Willie James Flagg Jr. That's my real name. But I'm under Derek Flagg right now.
Okay. You're the same person.
I'm the same person.
Got it. But like on your birth certificate or maybe a driver's license, it would say Willard.
Willie James Flagg Jr.
Willie. Got it. Okay.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
Medicine, I take high blood pressure.
Okay. Is there any medication that you would normally take that you haven't been given this morning or this afternoon?
I had some this morning. I had medicine this morning. I had some medicine this morning. High blood.
The high blood pressure medicine?
Yes.
How old are you and how far have you gone in school?
I'm 69 years old. I graduated.
Graduated high school, college?
High school.
High school. Where'd you go to high school?
Price High.
Pardon me?
Price.
Where's that?
That's located in Southwest Atlanta.
Okay.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes, I had enough time.
Do you need more time to discuss your case with your attorney?
No.
And are you satisfied with her services?
Yes.
Counsel, are you satisfied your client has a full understanding of this proceeding?
I am.
Also, do you waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
We do.
Mr. Flagg, do you remember being arrested on these charges?
Yes.
The state is unaware of any outstanding.
I was arrested on school. I was arrested on one of the burglaries.
Okay.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants related to these charges?
We are not.
No.
Okay. Mr. Flagg, do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 15 years to serve 5 with the balance probated?
Yeah.
Are you aware that the court does not have to accept that recommendation and that the court can sentence you to the maximum on each charge and can run those sentences consecutively, meaning one after another?
Yes.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yes.
Do you also understand that if you're charged with another crime in the future, that this plea may enhance that sentencing, including on a federal case?
Yes.
Are you currently on probation?
Yes.
Do you understand that if you're currently on probation, your probation may be revoked based on you entering this guilty plea today?
Yes.
Mr. Flagg, are you a United States citizen?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, or the ability to obtain employment.
Yes.
Do you also understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own your own firearm, and that if you did, you could be charged with another felony offense?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering this plea of guilty?
Yes.
You say yes.
So the court.
Yes.
Okay. Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Counsel, are you satisfied your client understands that these are the rights they'll be waiving by entering this guilty plea?
I am.
Mr. Flagg, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea?
No, ma'am.
Okay. As to indictment number 25 SC 003801, how do you plead to count 1, burglary in the first degree, count 2, theft by taking, count 3, possession of tools for commission of a crime, count 4, theft by taking, and count 5, criminal trespass and damage to property?
Guilty.
As to indictment number 25 SC 005371, how do you plead to count 1, burglary in the first degree?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Freely.
And do you feel like you understand what we've been talking about?
Yes, sir. I understand.
Good.
Do you understand that you do not have a right to appeal directly from your guilty plea? But if you believe there's an error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
Yes, ma'am. I understand.
Do you also understand that that must be done within 30 days from today?
Yes, ma'am.
Do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this plea?
Yes, ma'am.
Thank you, Mr. Flagg. Your Honor, if this case were to proceed to trial, the state would show in the indictment ending in 3801 that on June 27th, 2025, Officer Warren of the Atlanta Police Department responded to a burglary call at 874 Welch Street. That's Atlanta, Georgia, and also in Fulton County.
Can you spell the street name?
Yes, WELCH.
Welch, thank you.
Welch, yes. When the officers got there, they were able to speak with, when the officers got there, they saw the back door of the house that's at that location open, and the officer went into the home and cleared the location. The house was left, and the officer said, in a mess, like someone had went through every drawer that was in the home. As the officers continued to walk through the home, They were able to determine that whoever came into the house through a window through a rock at the window, I'm sorry, gaining entry to the home. And also, they were able to speak with the neighbor who said that the incident of the defendant entering the home was caught on surveillance camera. On this day, the defendant was not arrested for these charges. However, a couple of days later, the officers were canvassing the area where they saw the defendant. They saw the defendant, and because of a burglary that happened a couple of days before this, which is the other indictment, they were able to identify the defendant, Mr. Flagg, as being the person who entered the home of this victim to steal the copper out of her home. And those are the facts of the case of the indictment ending in 3801. For the facts of the case of 5371. If this case were to proceed to trial, the state would show that on June 23rd, 2025, Officer B. Citizen of the Atlanta Police Department was dispatched to 975 Welch Street. That's the same spelling, Welch Street, Southwest Atlanta, Georgia, occurring in Fulton County on a burglary call. When the officers got there, they were met by Miss Logan Thread, who was the victim in this case, who stated that she left her home. She was advised by her neighbor, Mr. Dwayne, that an unknown male had entered her property the same day she left around 2:30 p.m. She stated that once she got this call from the neighbor, she called the police officers and let them know that someone uninvited was in her home. It was determined that the defendant, Mr. Flagg, entered the home through a crawl space, went inside of the home and took the copper out of an AC unit that was in the home. Also, in this case, Your Honor, there was a camera on the home that was able to show Mr. Flagg being the one going into the house to take the copper out of the home. At this time, the warrants were placed for Mr. Flagg. The neighbor that initially told the victim in this case that someone had entered her home was able to identify Mr. Flagg as being the same person that was shown on the video footage of the person walking into the victim's home and stealing the copper. At this time, the warrants were issued for the defendant, and he was arrested for the charges we have before us. And those are the facts of the case with the indictment ending in 5371 regarding
Both on Welch Street.
both on Welch Street.
Okay.
Yes. Regarding the negotiated plea between the state and defense, we're asking for a global offer in this case of 15 years to serve 5 with the balance probated, with the condition that the defendant complete RSAT while he's in prison. Regarding the special conditions of probation, we're asking for the restitution to be reserved. We have confirmed the amount for one victim, but not the other. So we're asking for that restitution to be reserved for the defendant to stay away from the victims, stay away from the incident locations, for the defendant to complete an anti-theft course, and for him to be gainfully employed. And that's all from the state, Your Honor.
Okay. Thank you. In terms of criminal history, it sounds like 43 cycles. And then I have a recidivist notice that lists 12 convictions to include 7 earlier burglaries.
I got 7 burglars.
Okay, we've got the same count. Six or 7. I mean, I counted 7 on there, but I may have miscounted. Plus some other things, but that's not what this case is about. Okay, thank you. Ms. Smith, before I turn to Ms. Wood, there is a recidivist notice filed that makes for a different sentence. So I'm curious if you are withdrawing it for purposes of this plea or leaving it in place, if it's A and C or just one of the letters or none of the above.
Yes, Your Honor, we're withdrawing under A, but not C.
Okay, got it. Understood. Ms. Simpson, is Mr. Flagg still on probation for any of his cases?
He is still on probation for docket 14 SC 126264.
That's probably why that one was spelled out. Okay.
And he has 5 years, 10 months remaining.
And since that's a 14 SC case, these would both be bases to revoke.
Yes, Judge, but that was, with Judge Squall in August of 2020.
Oh, and he already did whatever he was going to do?
Yes, Judge.
For both cases?
I see the 14. That is the only case that he is on probation.
Oh, when I say both cases, meaning he was revoked in the 14 SC case for both. Got it.
Yes.
I just don't want to leave something hanging for Mr. Flagg where he needs to come back and deal with things. We should try to, okay, understood. Thank you. Now, Ms. Wood.
Thank you, Judge. Mr. Flagg is 69 years old. As you heard, he's a lifelong Atlanta resident. He is a high school graduate. He does have a sister who lives here in the metro area. Judge, he has been in custody since last summer, June 27, 2025. We would ask that he gets credit for all of that time. Your Honor, we are asking for him to receive residential treatment. I did speak with Ms. Simpson because I can't remember how it works when you're wrapping it into a regular prison sentence. I think it can be recommended by the court, so we'd ask for that. It's our belief that this all stems from self-medicating and everything that's related to that. And we had tried earlier in my representation of Mr. Flagg, my office, we were hoping to find a program so that we could do this maybe not negotiate in a different way. And unfortunately, given some of his history, we were unable to place him.
Right.
And he also wanted me to ask the court, I know that you cannot make the Department of Corrections do anything, but he wanted me to request the court to maybe recommend that he be able to participate in a transitional center or work program towards the end of his sentence, if possible.
Sure. Those are all fair requests and would make sense if you're doing well in terms of taking care of yourself and staying out of trouble, which I suspect you will, in the Department of Corrections. Those would make sense. Mr. Flagg, do you have anything you want to add to what Ms. Wood has shared?
No, sir.
Is there a drug or a substance that you have struggled with in particular at this time in your life, or you just were hustling for copper?
No, cocaine was my.
Okay. How long have you struggled with cocaine?
Ooh.
Long time.
Over 50 years.
That's a long time. Ever received treatment?
I'm sorry, I've never had treatment. I done asked the court in the past, could I get treatment? They won't give me treatment. They say I'm not qualified for no kind of programs or nothing. I need to have a program or nothing.
Two different things. I don't know about the qualified as in you don't need it. I think you need it.
I need it.
You picked up a conviction a long time ago that makes it hard to put you into programs because and so we don't need to go there, but it's a collateral effect, as we call it, of you've done your time for that and you've moved on and what happened was bad. But this carryover effect is now when people look at, okay, let's learn about Flagg. Oh, that happened. He can't be in this program. And that may seem unfair, but they need to draw some pretty bright lines just to be safe. And you may be 100% safe now, but if this had been just 2 years after that other situation, you could understand why a program would say, let's not have Mr. Flagg in this group. So unfortunately, that's denied you the opportunity to get some of the treatment you need. I'm hopeful that the Department of Corrections will step up because you won't be denied there. There are going to be people who are working through situations far worse than yours, and they get treatment as well. So, Mr. Flagg, I find there's a factual basis for both these cases. You were breaking into houses. You weren't hurting people, but you were taking stuff that wasn't yours, and that is very intrusive, and it scares people. And frankly, these are your 8th and 9th burglary convictions. So it's time to get you moving in a different direction. You still have years left too, so I hope this works. I also find that your pleas are knowing and voluntary, meaning you've understood what we talked about, and no one's forcing you to enter the plea. Any questions thus far?
No, sir. No questions.
Ms. Wood, can someone in my office sign both the indictments for you?
Yes, Judge.
Ms. Smith?
Yes, Judge.
And Mr. Flagg, can we put your signature on both of the indictments indicating your guilty pleas?
Yes, sir.
All right. Well, I will follow the joint recommendation in the 2 cases. I'm sentencing you as a recidivist under subsection C. And for whoops, where did the indictments go? In the case ending in 801, the sentence as to count 1 is 15 years to serve 5. For 2, 3, and 4, it's 5 years to serve. And 5 is a misdemeanor, so that's 12 months to serve, and they'll all run at the same time. So that's 15 to serve 5.
Quick question.
Yeah.
Under the statute, I know that once he gets over 4 burglaries, it can't be suspended or probated. So I was gonna ask for count 1 to just be the 5 years to serve, unless you do it.
Oh, no, if that's, I'm not disagreeing with you. I didn't realize that.
The 4th or subsequent convictions cannot be probated or suspended, so.
Okay.
whatever we give is what it is.
We're gonna build your sentence in a different way. So I'm gonna start over again. Count 1 is 5 years to serve. Count 2 is 5 years consecutive to count 1, but it's probated. Count 3 is 5 years consecutive to count 2, but it's probated. That gets us back to 15 to serve 5. 5 to serve, 5 probation, 5 more probation. Count 3 would be 5 to serve concurrent with count 1. And count 5 is a misdemeanor. That's 12 months to serve concurrent with count 1. Same sentence, 15 to serve 5, just different building blocks. In your other case, the case ending in 371, is 1 count and it's burglary. I'm sentencing you to 5 years to serve. That will run concurrently with your sentence in the other case. I need to set a condition or 2 of probation in the case ending in 801, because you will have some probation when you get out. Number 1 is stay away from Welch Street. You just gotta not be on Welch Street. You can be other places in Atlanta, but not there. And number 2 would be that you submit to a drug and alcohol abuse evaluation. And if that expert, a doctor or a therapist, recommends any treatment, then you get that treatment. I'm hopeful you'll get treatment while you're in custody, but if for some reason you don't, let's start applying it when you get out and you are on probation. I will recommend to the Department of Corrections 2 things. 1, that you participate in their residential substance abuse treatment program. That's intensive drug treatment. I can't make them do it, but I hope they evaluate you for that. And number 2, that they consider you, if you do well with RSAT, to participate in some workforce transitional programming at the end, where you might end up at Metro reentry. They call it Metro reentry, where the last bit of time you're in, they're getting you ready to hit the ground running, as opposed to I'm back home, I have no support, and I'm gonna go to my own ways. So I hope they listen on those things. Do you have any questions about any of that?
No, sir, I have no questions, sir.
All right, Ms. Wood, anything else for Mr. Flagg?
No, Judge, thank you.
And Ms. Simpson, we don't need to do it with a revocation because Judge Swall handled that. All right, anything, Ms. Smith?
Yes, really quick, on the indictment ending in 3801, count 4 is a misdemeanor.
Oh, okay.
So that.
The dollar value was such that it's a misdemeanor?
What is this? Yeah.
Okay, then that needs to be 12 months. So count 4 is also 12 months to serve concurrent with count 1. We still get to the 15 through the first 3 counts, and then we have 2 misdemeanors. Okay, thank you for catching that, because they would have just bounced it back. All right, thank you. Good luck, Mr. Flagg.
All right, sir.
I'll give it to you, John, you get. Okay, here you go. All right, so keep this with you, okay?
Correct.
All right. All right, take care.
Okay.
Take care. Mr. Abadi, I agree orally, I haven't done it in writing yet, to amend Mr. Williams's bond so it becomes a county-funded ankle monitor. They're ready for trial and he's having to pay that and he's ready to go. And I just can't fit it in the calendar yet, so take that expense off, but nothing else changes, same curfew and all that stuff.
Thank you.
You're welcome. Ms. Smith, I think that's it. Super, then it's not it. We'll do that, but we're going to talk about Nevada Twitchell first. So Mr. Twitchell, if you'll come up and sit with Mr. App, please. So last trial calendar, Mr. Twitchell was here, Mr. App, one of your associates was here, doing a great job trying to manage things. But Mr. Twitchell, I think reasonably said, I want more time with Mr. App before I decide if the state's offer is what I want to do versus going to trial. And these are complicated cases for a defendant and even the ablest of defense attorneys, because the results are the results, and it's not a intent crime of Twitchell meant to do this. It's he was driving in a reckless way, assuming he was, and someone died, and a lot of consequences flow from that. So I understand it's not easy, but the state's also not going to roll in and say, how about misdemeanor probation? So I need to know where we are, and if where we are isn't, it's a plea today or we're ready for trial on the 23rd, then I need to know why we're not there, because this is an older incident.
I respect and appreciate that it's older. And I try very hard, Your Honor, to be very forthright with courts and prosecutors about, cases that I'm going to go to trial on versus, okay, we're going to work something out or do a non-negotiable plea or whatever. But rarely, occasionally, I have to bluff the state, but this is not one of those cases. And I've been very forthright with Mr. Abate, and I'm going to be forthright with the court. This is, unless Mr. Twitchell tells me otherwise, I do not expect this case to be a jury trial. I fully expect it to end up being essentially a non-negotiated plea. I am waiting on an expert report from Mr. Tomlin, who has done a computer forensics accident reconstruction of this incident. And then I'd like to meet with Mr. Twitchell and review that report. And then I'm even happy to set it down for a plea date now. And look, I understand and appreciate if the court forces us to move the case quicker than we would like, then we're here at the mercy of the court, and we respect that very much.
What's the ETA for the expert report?
I should have it. According to Mr. Tomlin, he's working on it and says he promises to get it to me by the end of March. Probably not what the court wanted to hear, certainly not what I wanted to hear, but I would be happy. And I don't think Mr. Abate, having talked to him, I don't want to speak for him, but I don't think he's, pressing to get this case done super quickly. I understand the court might need to. But if we can set it for a plea date in either late April or early May, then we'll get this case off the court's docket. I will tell Your Honor for certainty this case is not going to trial. There's no way, regardless of what Mr. Tomlin's report says, that we can try this case. And so we don't want to try it.
So his report may strengthen your, call it mitigation, leniency argument, but it isn't going to be a magic bullet. Look, Twitchell was in Texas when this happened.
Right. I mean, I tried one of these cases 4 months ago, 5 months ago in Douglas County. And, we were lucky we got an acquittal, but it's a lot of science and it's a lot of computer forensics. And I mean, I'm about Your Honor's age and I don't like technology. So I have to rely on experts for all that stuff. But this is not one of those cases. I do not expect any scenario, unless my client wants to go against legal advice, to end up in front of a jury here. Okay. I do expect to put together a mitigation package and present that to court and put together argument. But if the court will indulge us for, another 5-6 weeks, then I think we get the case resolved.
Okay. Mr. Abate, you are in touch with the victim's family. What are they pressing for in terms of timing? They want closure and they may want a particular sentence. I'm not asking about that. I want to balance things. It's not a crazy ask. I'm not going to be interested in shifting it again if Mr. Tomlin says, I meant late March, but my hard drive crashed. I would think we would try to lock in a date in April for a plea that works with your schedule and Mr. Apt's. But that's a couple months from now, and you may have a victim family that a year ago was saying, what's happening?
I think April will be fine. I mean, a year ago, they always wanted to end sooner than later, by all means.
Sure.
But I think in the interest of all parties getting this to close in an equitable fashion for everyone.
And to not have to go through the trial, the family to not have to go through the trial. Okay.
It's perfectly fine.
Okay. All right. Mr. App, then what I will do is have Ms. Nelson reach out to you and Mr. Abadi to see, what are 2 or 3 dates in April where this could work.
And I have a humble suggestion, if the court would indulge it. I have a leave for an entire week in April, but I'm not going out of town. And if we can schedule it on a date when I'm on leave, I will come in so that I can't, some other judge somewhere else in this courthouse or in another county can say, hey, you got to come in and try it, or anything. And that way, I know I'll be here. I know that's a horrible way to spend your vacation working, but that's, I think, necessary. And so,
what week is that?
So that sort of vacation is the week of April 6th. And so as long as the word doesn't get out too much that I'm waiving my leaves to come into court.
Mr. Abadi, that is spring break for some sets of schools, and sometimes that's a conflict for you. Are you around the week of the 6th?
Yes, I'm not going on spring break.
Okay, but I mean, you may.
Yeah, I'll be here.
Some could have come up. I just want to, I'm glad that it works for Mr. App, but it takes 2.
Whatever day the court schedules during that week, I'll be here.
Okay, then I will work with Ms. Nelson. That happens to be an open week for me because it's spring break and we're going to go somewhere, but my kid made a sports team and now he's not allowed to leave. He has to be here for games. So I'm grounded. So we'll work through this.
Thank you, Your Honor.
Mr. Twitchell, you followed what Mr. App's been talking about? The important part for you to understand is that your lawyer is committing you to being here someday that first week in April to go forward with a plea. It may be a non-negotiated plea where Mr. Apt is saying, Judge, you need to give us this thing different from what the state's asking for. It may be, we agree, but one way or the other, it's the time that you're going forward. Now, I want to be clear because I need to be legally correct. I can't make you plead, nor can Mr. App. So you can change your mind, but your lawyer is saying in no uncertain terms, his professional advice with many years of criminal defense under his belt is that this is a case that's going to resolve by way of plea. And he's just now said it needs to be the week of April 6th. And I'm saying we'll do it then. So as you are preparing yourself, that's what you ought to be ready to do that week, because if in the end you put the brakes on it, which you have the right to do, and say, you know what, I can't do this, Mr. App, then I will find a very close date after that to say, fine, we're going to trial. And you don't get to say no to that part. If it's a trial, it's a trial. And the jury sees the pictures and hears the testimony and looks at what happened, and you have to work through the consequences of that. Okay? I just want to spell it all out because I know you haven't been through something like this before. And this is different. And given what the charges are, the state's recommendation is probably going to be one where you're going to be out of commission for a while. And you need to be as ready as one can get for that. You just need to be ready for that's a potential outcome of a plea. It's certainly a potential outcome if you go to trial and you're found guilty. So we're not changing the stakes. It's just generally when there's a plea, your lawyer has a better ability to get the state to stay within a range that he can argue for, as opposed to now 12 people have heard all about it and I've seen pictures of what happened and all that. Okay? All right. Sounds like you understand. You remain on bond. I know you had asked me to modify your bond and I didn't get around to that, but I'm not going to, given what's going on. You just need to do your best to stay on the straight and narrow between now and your plea date, because that'll only help you. If you show up and it's like, oh, yep, and then there was a DUI, that the state will eat that. They'll be they'll let me know all about it. So, Mr. Abadi, anything else in the Twitchell matter?
No, Your Honor.
Okay, Mr. Apt, we will find a date and time. Now, with this expert and this report, do we need to block out half a day for the plea?
I think half a
Couple
day is
hours?
probably too much. And I don't know how big of a presentation Mr. Abate will have, but I would think an hour. I don't think I think a half a day is too ambitious.
Okay, all right.
A solid hour.
Okay, not a loose hour. All right, we'll do that. If there's nothing else in the Twitchell matter, then I'm impressed we got Mr. Apt in court. It's a rare event. And we may go 2 for 2 in April. I will see you guys.
Oh, and are we off the record?
None of this was on the record.
Oh, great, even better. So and I'm just gonna were you friends with Don Hensel? Does that name ring a bell?
The deceased spouse of Wendy, yes.
Yes, and
Wendy in particular, I knew.
Yeah, Wendy Fritzen.
Yes.
Is probably how you knew her.
Yeah.
But I was very good friends with Don and haven't really kept in touch with Wendy since she moved away from Atlanta. But my college roommate introduced me to them, a guy named David Gemertz, who's a lawyer here in Atlanta. But
got it.
You had a lot of people in your law school class.
Kevin Warsh, the new head of the Fed, was my law school classmate.
Look at that.
I'm famous now. All right, we've got another plea.
Thank you, Your Honor.
You were famous before that, so.
Infamous. Yes, should we go out there? Can we bring, who is the last? Yes, is he bringing them out? Good.
Can we sit down? Oh, okay.
Go, we got it.
Okay, that's fine. Yeah, we can take photos. You're in trouble. You're in trouble.
Yes. A little bit. I'm gonna show the time over there. I'm gonna tell it. Or put me in motion, I'm gonna pay a
I take it, turn it back over.
He's like on the old cabin, used to be there, but it's just so good when you're here.
It's all soft now. It's just the bottom part.
Mark 45, right? Right.
That's it, bro?
It is.
Yeah, I got my first, very, all my resources.
So that's the wild card. Emerson's good. He said, I know it takes long and it may spill over to next week. Great. I would think so. And she's asked recently, why are my cases not going? Like, because they could continue.
Thank you.
You bet.
Bye. You want to sit down?
Do we have?
Okay, what'd you say?
Yeah, have a good rest of your day.
See you, Adam.
Hold on, I got too much paper. Here it is. You're Mr. Wilson.
Yes, sir.
All right, let's do this. This is the first position on our add-on calendar. We'll have knocked out the whole add-on calendar. Great work, team. It was much more productive than the actual trial calendar. This is Kendrick Wilson. 25 SC 004794. Mr. Wilson is here with Ms. Wood. Ms. Smith is representing the state, and Ms. Wood tells me, Mr. Wilson, that you're ready to enter a plea. And I think you understand that as a consequence of your plea, we're also going to do a revocation, that you have an open case or cases that are in Fulton County, and I'll deal with a revocation in those cases as well.
Yes, sir.
You got that?
Yes, sir.
Okay. Ms. Smith's going to put you under oath. Make sure you answer all her questions carefully and truthfully. You may have questions, and I won't know you have them unless you ask them. So will you please ask anytime you've got a question?
Yes, sir.
Okay, then we're ready for you.
Mr. Wilson, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can lower your hand. Please state your true, correct, and legal name.
Kendrick Douglas Wilson.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
And is there any medication that you would normally take that you haven't been given today?
No, ma'am.
How old are you and how far have you gone in school?
I'm 53 years old, and my birthday is March 8, 1972. That's when I was born. I didn't finish school. I had to I got to pick the GED up.
You did your GED?
No, I need to pick it up.
Okay.
Because I didn't finish the 12th grade. I stopped at 12th grade.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes, ma'am.
Do you need more time to discuss your case with your attorney?
No, ma'am.
And are you satisfied with her services?
Yes, ma'am.
Counsel, are you satisfied your client has a full understanding of this proceeding?
I am.
Also, do you waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
We do.
Mr. Wilson, do you remember being arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants related to these charges?
We are not.
Mr. Wilson, do you understand that this is a non-negotiated or a blind plea and that the state will recommend a sentence to the court?
Yes, ma'am.
And were you made aware of the state's prior offer of 7 years to serve 2 with the balance probated?
Yes, ma'am.
Do you understand that the court can impose any sentence authorized by law, including a higher sentence than recommended by the state, up to the maximum sentence on this charge?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yes, ma'am.
Do you also understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including in the federal case?
Yes, ma'am.
Are you currently on probation?
No, ma'am.
Well, I thought we had a revocation that we were working through.
Probation?
You didn't know you were on probation?
No, I just thought, I went to court on it and the judge, he threw it up. He suspended everything when I went to
Okay.
court.
We'll talk about it. I think you probably are on at least 1, if not 2 cases. You got some other second-degree burglaries that are pretty fresh, but the lady in red there is going to know the answer. She is with probation. She's got your info probably right in front of her. So we'll turn to her in a little bit.
Yes, sir.
We'll address that probation revocation, but do you understand that if you're currently on probation, your probation may be revoked based on you entering a guilty plea today?
Yes, ma'am.
Mr. Wilson, are you a United States citizen?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, or the ability to obtain employment.
Yes, ma'am.
Do you also understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm, and that if you did, you could be charged with another felony offense?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you also understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Counsel, are you satisfied your client understands that these are the rights they'll be waiving by entering this guilty plea?
I am.
Mr. Wilson, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea today?
No, ma'am.
As to indictment number 25 SC 004794, how do you plead to count 1, burglary in the second degree, and count 2, criminal damage to property in the second degree?
Guilty.
Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you do not have a right to appeal directly from your guilty plea? But if you believe that there is some error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
Yes, ma'am.
Do you also understand that that has to happen within 30 days from today?
Yes, ma'am.
Do you understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this plea?
Yes, ma'am.
Thank you, Mr. Wilson. Your Honor,
Thank you.
if this case were to proceed to trial, the state would show that on April 3rd, 2025, Atlanta Police Department officers were dispatched to a reported burglary that happened around 4:15 a.m. at the Smoky Stallion Barbecue Restaurant that's located at 390 Nelson Street, Southwest Atlanta, Georgia, also in Fulton County. Upon arrival, the officers observed a broken front window and then reviewed the security video footage. And in that footage, the suspect, who was later identified as the defendant, Mr. Wilson, was wearing a black hoodie, green shoes, and camouflage pants. And he was seen on the camera going into the restaurant after breaking the window around 4 a.m. He then returned outside of the establishment with a suitcase that the officers later found on him also when they caught up to him. The suspect fled afterwards, but was then, when they canvassed the area, the police officers were able to find him sleeping by a street at 183 Forsyth Street. And that's also in Atlanta, Georgia. At this time, the officers identified him as the person who broke into the establishment and detained him and arrested him for the charges we have in front of us today. And those are the facts of the case regarding the sentence that the state is going to be recommending today. Regarding count 1, the state is going to recommend 2 years to serve. And for count 2, we're recommending 5 years to run consecutive to count 1 for a total of 7 years to serve 2 with the balance probated. Regarding the special conditions of probation, the state is going to be asking for the defendant to stay away from the incident location, to have no contact with the victim, to be gainfully employed, also for the defendant to pay $1,600 of restitution. We've received those receipts from the victim in this case, and also for the defendant to enter and complete the Salvation Army program that he's been accepted to. The state did have a chance to speak with the victim in this case, and he stated that he just really wanted to be reimbursed for the alcohol that was stolen from his restaurant.
So that's what was in the suitcase. That was going to be one of my questions, is what Mr. Wilson got out of it. It was a suitcase full of liquor.
Yes, Your Honor.
Okay.
So that's the only thing that he's really requesting when it came to any statements he wanted me to make to the court on his behalf.
Okay. And he would be the owner of the Smoky Stallion Barbecue Restaurant?
Yes, Your Honor.
Okay. So the 1,600 is for liquor, or it's for the broken window, or it's both?
A conjunction of both, Your Honor.
Okay. Got it. Okay.
That's all from the state.
You filed a recidivist notice. Mr. Wilson qualifies. He's got at least 7 felonies to include 4 burglaries. Are you making that a C only or no recidivist for this plea?
C only, Your Honor.
Okay. Got it. Thank you. I didn't see his name on your magic sheet, but there's an add-on. Oh, it's just a different name. Okay, let me take a look. I did find his recidivist notice, so that's how I knew about all the convictions. Oh, yeah, okay. It's just Kendrick, not Wilson. Understood. 16 cycles, on probation for 1 burglary. That's what we'll talk about. And all the others. Great, thank you. Ms. Simpson, what is Mr. Wilson's probation status? How much he has left, and has this already been accounted for in that case?
Judge, he is on, as stated, on probation for docket 24 SC 00566. And he has 1 year, 6 months remaining.
That's missing 1 digit. 24 SC 00 000. Got it. Okay. 000
Yes.
566.
Yeah.
And he has how much left?
1 year, 6 months.
Got it. Okay.
And to answer, questions that he was asking, so he was originally, on probation for 2 dockets. He had a revocation in May for this case before Judge Mao, not for these charges, for something separate. And then he had a revocation on another docket before Judge Dunaway. The case with Judge Dunaway, he terminated the rest of that probation.
Got it. So he's remembering correctly that a case was shut down, but that's not the 24 SC, and there's been no revocation in connection with the Smoky Stallion burglary.
That's correct. So Judge Mao just continued him on probation. So, and he picked up these charges, well, the warrant came for these charges a month after that hearing.
Okay. All right. Understood. Thank you. Ms. Wood.
Thank you, Judge. So this is one of the cases that we were trying to get him into drug court in the fall, and because of the very old armed robbery conviction.
Oh, this is the,
Yes.
right, that's, okay.
Yes.
Alright.
So it's been a little bit, Ms. Ross has had a little bit of difficulty finding placement. However, she was able to set him up with an interview with Salvation Army yesterday. They've accepted him. That is an inpatient program, 6 to 12 months. They offer anger management, Alcoholics Anonymous, and Narcotics Anonymous meetings. There's some other classes that are involved. And then, of course, participants work at the adjacent store and get like a gratuity, something. So he has been accepted into that. I don't have a release date yet. That's kind of why we're going non-negotiated. The only other thing that we're differing with the state on is count 1. I'm just asking for it to be the 310 days that he's already served, and then the 5 years probation on count 2 to run consecutive. I would ask for a restitution hearing, and then I believe he receives disability, so I'm not sure about the gainful employment aspect. But otherwise, that's our request of the court judge.
Okay, thank you. Those all make sense, those requests. Mr. Wilson, your last 2 Fulton County arrests, you were in jail for a long time. One of them, you were in 500 days for another 2nd-degree burglary. Are the bonds just too high, or do you have no bond, or?
It was just something to do with the system. I don't know what it was.
Okay, well, that's not the system working well. I'm sorry that you waited that long in this case and in that other one. You should know Ms. Wood, when she gets a case, pushes it. You're here, it has not been moving much. I need to say this the right way. It has not been on this docket for very long. I appreciate that the conduct was back in April of 25, but since then, Ms. Wood has been moving the case along. It didn't get indicted for a while, and then she waived your arraignment, and boom, here we are. So we shouldn't have to wait quite this long to resolve 2nd-degree burglaries. Although this is a lot faster than your last one. Last one was another 7 months. So, okay, do you have any questions about what we've been talking about?
I'm just really happy that she came forward with some type of help.
Have you not had
I never had no
programming like that before? Okay. Well, that seems to be a theme this afternoon. Mr. Wilson, I find there's a factual basis for your plea. Pretty clear what happened. You're caught on video. You're caught nearby later on. Also find that your plea is knowing and voluntary, meaning you've understood what we've been talking about and no one's forcing you to enter this plea. You agree with me?
Yes, sir.
Okay. Ms. Wood, can someone in my office sign the indictment for you?
Yes, Judge.
Ms. Smith?
Yes, Judge.
And Mr. Wilson, can we sign the indictment for you?
Yes, sir.
We'll do that. Do you currently receive SSDI or some type of government benefits?
I haven't started yet. So when I got locked up this time, I had my finger amputated. I got bit by a spider. They wouldn't let me in the jail at first.
Okay.
I stayed in Grady like 6-7 days, then they brought me over to the jail.
You got bit by a spider in the jail or out where you were?
Outside the jail.
Okay, and then it was so bad that they had to
Amputate.
whole finger?
Yeah, my whole thumb.
Oof. Okay, that's a bad spider. Sorry about that. So have you applied for benefits or you suspect you will?
Only benefits I applied for was food stamps.
Okay, got it. Are you right-handed?
I can work.
You can work?
Yes, sir.
Okay,
Yeah.
all right. I just want to explore that because I don't want to say, hey, you need to work if that doesn't make sense.
I love working. I work.
Okay, good. They didn't amputate your whole arm, it was your thumb.
Thank God.
Still not good, but dangerous spider. Okay. Well, Mr. Wilson, what I'm going to do on count 1 is to sentence you to 1 year and 6 months. I am sentencing you as a recidivist pursuant to subsection C. At count 2, I am sentencing you to 5 years probated consecutive to count 1. So you will still have 5 years probation after you serve the custodial part of your sentence. Special condition number 1 of your probation is stay away from the smoky stallion. Number 2 would be to participate in the Salvation Army program, assuming they still accept you into it. I don't mean to set you up for something you can't do, but if they accept you into their program, when you're released, that's where you need to go to get some support, okay? And you need to complete their program. It's not just you show up once and get a warm meal and say, I'm out of here. It would be to successfully complete that. You'll need to submit to a drug and alcohol abuse evaluation, and probation will help you connect with a medical professional there, and that person will just figure out, hey, would you benefit from some treatment? And if treatment is recommended, that treatment becomes part of your probation. Finally, because you are still young and able-bodied, within 2 months, and you say this the right way, starting the 3rd month of your probation, you need to be working at least part-time, that's 20 hours a week, or you'll be doing 10 hours of community service each week. So either you'll be volunteering or you've been able to land a job that you can document. So it's not just a hustle on the side, but here's my pay stub or my boss signs this sheet showing that you're working at least part-time.
Okay.
Okay? Does that seem fair?
Yeah.
Okay. Well, then that's what we're going to do. Ms. Wood, anything else on behalf of Mr. Wilson?
I got one question though.
Sure, you start.
The sentence you give me, that means I'm going to prison?
So it's a good question. You get credit for all the time you've been in. They're going to do some math out at the jail. I think you probably will. I think it's just long enough that you're going to go to the Department of Corrections. I don't know that you'd ever leave Jackson, which is where you go first, the diagnostic facility, because there's not a lot of it left that you need to serve, but you're going to need to do all of it. And so I think it's long enough that the sheriff's team is going to say, that's longer than we can hold him here, because as you know, that jail's pretty full. Okay?
Yeah.
All right.
So his final plea rights are preserved, Judge, so technically we could withdraw it if.
Oh, okay.
Because his final plea was on Tuesday.
Okay,
Yeah,
right.
we just continue it.
We didn't, right.
If you want to talk about it, we can.
So let me reiterate what Ms. Wood just said. You are taking this plea when you still have the ability to say, no thanks, Judge, I'd rather go to trial. You know what the facts are, what the evidence is. You also know that the state asked for 2 years, and I gave you 1.5 years. But your lawyer basically said, let's get him out as soon as the program has a bed. And I gave you a little more than that, less than what the state asked for, but more than what your lawyer did. So if you want to say, no thanks, I'm going to sit tight at the jail till I can have a trial, you're free to do that. You've got that ability today. After today, if you enter a plea, you're stuck with whatever sentence you get.
I'm good with what's going on. It's just the fear of me going to prison.
Okay.
I
Understand that, but the 2 years would have gotten you there, and you know that's what the state is recommending without even a trial. So what you and Ms. Wood, you can talk to her about it, should think about is a trial going to go well? And if it is, if it's likely that the jury would say not guilty, then maybe that makes sense. But if the jury might say guilty, the state might not be saying 2 anymore, because then the gentleman who owns this Smokey Stallion would have to come testify, and state might say, how about 5? And those are bigger numbers. So if you want to talk some with Ms. Wood, she can step back there with you. If you know what you want to do, we can go forward.
I'll go along with it. Just my host will just like going to a program. I just didn't.
I get it. That's a reasonable.
I'm good.
Okay, then we're gonna do this. Here's the other thing. I don't want to forget this. You in 24 SC 000566, that's your open case. I'm gonna revoke all that probation, but that's the same length of the sentence I just gave you. So that case will be closed out. When you're done with your custody time, you're just on probation for this case. Okay? So I'm revoking, well, I want to not overstate it. It was 1 year and 6 months. Okay, that's what I'm revoking. And that's the 18 months we have on count 1. Look at that symmetry. Ms. Smith, anything else for the state? Okay, if you end up, speaking with the Smokey Stallion, want to have a restitution hearing, just let us know. We'll schedule that. Ms. Wood can be here. And if Mr. Wilson is still local, we'll bring him over. All right, thank you.
Okay, thanks. All right.
You're welcome. Good luck to you.
Good luck, Mr. Wilson.
Thank you.
Do we have anything else?
That's it.
What a productive day. Thank you. Let me, before I say happy Friday the 13th, we have a revocation calendar tomorrow, and I'm looking at it. 1 goes away. I think position 1, someone sent a consent, so I'll deal with that. Number 2, whoa. So you're off the hook. All right. And it's not Ms. Wood. So they will come in and we will deal with that. All right. Thanks, everyone.
Let me ask you a question.
Yes.
When the ladies go when they get their time down the road, do they have to go for diagnostics? Do they have to go to Jackson?
So no, they go to a